ಇವತ್ತವರೆಗೂ ಇದೆ ಅಂತಾನೆ ಎಲ್ಲ ರೆಡಿ ಮಾಡಿದ್ದೀವಿ ಮೇಡಮ್. ಸ್ಟಿಕ್ನಲ್ಲಿ ಇದೆಯಾ ಎರಡೂ?
Lordship, kind permission. 2021 RPFC, my lord. I appear for the respondent wife. That in spite of the order passed by the family court, no maintenance has been paid by the husband. I have filed application seeking for interim maintenance from the order of this honorable court, my lord.
Matter arising out of MFSC proceedings, my lord. Really, father's application for access to information details and all has been rejected by the trial. The notice has been ordered. It has to be heard, my lord. So, yes, yes, my lord. They have filed wakalat also.
My lordship, it is a 2019 matter. 2019 matter, my lordship. ನಾಳೆ ಹಿಯರಿಂಗ್ ಆಗಬೇಕಾಗಿ ಆರ್ಡರ್ ಮೇಲೆ ಅಯ್ಯೇ ಆಗಿದೆ my lordship. 19 matter.
2019 matter.
ಅಯ್ಯೇ my lordship.
Now you realize that there is urgency in it.
My lordship, it is a...
The lordship, MFSC 4577/46 was disposed of by the honorable court on 5/6/2020. Some typographical error is there on page number 4 and 7, your lordship. In a mathematical error.
This number 2 next week, your lordship. This number 2 next week.
It's a part matter.
Okay, some increment today. Some increment is there. Next week.
See what it is and delete it from partner when you're not interested to argue. Why should we keep it in partner?
At least on Friday, your lordship. Today is inconvenient, please.
I
Friday.
inform the other side.
No, I have to do it. We have to do it. He won't come, your lordship. That's also.
Other side will be there. They will not.
He will not object, I think.
That you cannot say. You will see.
I will inform you. There's some incoming.
Page-wise adjournments, page number 5, 14 to 22.
Serial number 21, my lord.
21.
Serial number 21, I have to file wakalat in the connected case. Lordship, I have it after next week.
Have you informed
21.
21, my lord.
Have you informed them?
And no, today it is come. I have not filed wakalat.
Because they have moved the
It
memo.
is not admitted. It is not admitted. They have filed it. I will inform, my lord.
They have moved a memo. We don't know what is their urgency. Please wait. Yes.
Serial number 14.
Huh?
Serial number 14.
Yes.
We have given to NOC Wakalat to respond. I am not recording on record.
There is something on record.
Already NOC Wakalat put it in responding. I am not in record.
Ashok Kumar H. You could NOC ಕೊಡ್ಬೇಕು.
Serial number 14.
Because given NOC, you should find a memo.
One week.
That is the memo of retirement.
No, not
Then you have to find.
Serial, page 6, 23 to 29. Page 7, 30 to 33.
Milots, serial number 30 Milots. Senior is not keeping well Milots. It can be taken tomorrow.
You appeal for who?
Petitioner Milots.
Have you informed the respondent?
Yes Milots. Yes Milots.
It is submitted that the counsel for the petition is unmet and the same is informed to the counsel and respondent. This is matter next week. Please call the rest.
Serial number 1 for being spoken to, MG Ravisha. He's not done.
No representation. Yes, next.
Serial number 2, Pathad matter. Serial number 2, Srinivasa KN.
Next week. Next week, please.
You are for the appellant.
Respondent yours.
Calls for the, no representation for the appellant. Calls for the respondent 6 times. Delete for partner. This is matter of 2 weeks. Yes.
Serial number 3, Kalyanar.
Pay for appellant. Due to some health issues, day after tomorrow, I'm ready.
Partner will start to 2 weeks.
On date may, otherwise day after tomorrow.
Take the date. Yes, next.
Okay. Serial number 4,
For the mother, request for a passover, my lord. Senior counsel's own legs. Please, my lord.
It is you have it, the orders and the date.
Let it be released, my lords, because this. Let it be released. Request for taken up next week. Yes. Yes, please.
5,
For the petitioner, my lord.
for orders, maintainability.
My lord, ಅದು relying on the judgment, maintainability. The para 18, my lord. Second para 18, my lord.
What is the way of, for what you're relying on this?
My lord, para number 18. The considering the above legal position, I am of the considered view of the order of maintenance effects of rights of person drastic and substantially. Yet it cannot be treated as an interlocutory order. The criminal review should be preferred under section 19 class 4 of the Family Court Act. Against the order passed of the application for interim maintenance by the criminal
What is the revision against an order of the family court?
interim order passed in the Family Court.
According to you, a revision is maintainable.
Yes.
What is the revision against the order of the family court? That is a petition under 227. Is it not?
Yes.
So what is the revision?
Here, passer my senior.
No passover, but that no argument is required.
The passer my senior is coming.
Objection, the officer raised objection with regard to the maintainability of the petition. And in your section 19 code, just give the file. Section 19 code of the family code side. The order that is passed by the family court is on the IA number 8 and granted maintenance
My lord, please pass on my senior coming, my
an
lord.
amount of rupees 75,000 each to the petitioner number. You are not going to lose anything. I will permit you to convert this petition as
Okay,
a
okay,
petition.
okay, my lord.
Each to the petition numbers 2 and 3. The office has raised the objection with regard to the maintainability in view of section 94 of the Family Court Act. And council has relied on an order passed by the Uttar Pradesh High Court in case of Pawan Kumar versus State of UP, wherein against the interlock grant of maintenance, an application is filed under section 482 of the CRPC. And the court had ruled in the said order that a revision is against order passed by the family court. A revision is maintainable in any view of the matter. When an interlocutory order is passed by the family court, the petitioner can only file a writ petition with 227. Accordingly, the office objection is sustained and the petition is at liberty to convert this RPFC into a writ petition within 1 week from today. Yes.
Serial number 6.
Grateful, my lord.
Then
Appearing for petitioner, your lordship, I may be permitted to convert this petition from RPS
Same
to
order, next order.
grateful, your lordship.
Without the judgment.
7.
Just for a week's time to, process was paid, but I don't know, in the trial court they are appearing, but they're not.
The petition is permitted to take out answers on the council appearing to the respondents of the trial court. It shall file a memo to the effect
Yes,
within a period of 3 days.
my interim order may kindly be extended.
If the interim order is extended, then this is matter on immediately after.
Serial number 8. B. Ramesh.
There are three connected matters between the parties. One with respect to, there is a civil petition. There is one more writ.
Michael, sorry.
There are three there are three matters connected between the same husband and wife. So all of them could be listed. One more thing says maintenance awarded has been completely stayed at the hands of this honorable court. 50,000 has been granted.
What is the husband's interest?
Husband.
Let's hear what has happened. Before deciding the application for grant of interim maintenance,
3,50,000.
as a precautionary measure, before deciding the application itself, a learned trial judge has ordered for directing the respondent to pay the maintenance.
How much is the
50,000. Entire amount is
50 or what?
yeah
50.
Kindly.
50. Now, who are the petitioners, wife and the child or only wife?
Only wife,
So,
wife and the child.
a wife and the child. When is this writ petition? 24. So from 24, you are not paying anything to them.
Lords, I am paying for this reason. Kindly refer to one application has been filed by this honorable court, by the registrar of this one, to seeking for direction to transfer the original the case to the original court. An application is filed. Here, what has happened?
You have to modify the income order.
I have no grievance for that. Only
You will tell the court what should be the amount. We hear it on the next subject.
I'll take instructions, kindly have this matter day after tomorrow.
This is matter day after tomorrow. By the time the bill comes to the petitioner, husband shall get specific instructions.
My lords, I may be permitted to intervene in this matter. I have filed an application to implead myself, my lords. There is an error of jurisdiction in this matter, my lords. The family court, my lords, on its own has sent this matter, my lords, to the senior civil judge, who has no jurisdiction to pass this order. We as a registrar, my lords, we had got a complaint about this. When we were looking into the matter, my lords, we realized, my lords, this matter is before this honorable court. The family court, my lords, sends it to the senior civil judge. And the senior civil judge has passed this order. This order is, my lords, without jurisdiction.
Because my lord, transfer itself was without jurisdiction. For this reason, my lord, a complaint is lodged against the presiding officer.
There could not be a transfer by the family judge, my lords. Section 7 of the Family Court Acts, my lord.
Because my lords, the application itself is not disposed of. Application is pending for interim maintenance.
Wife and child has to sustain.
No, my lords. My lords, it is not without contest. My lords, there is no order on IA1 for interim maintenance. No order has been passed as on today, my lords. It is pending consideration. During pendency of that application, interim maintenance of what my lords are sought for in the application is granted.
What is the purpose of this instruction? When is that application filed? Where are we now? And how will the wife sustain?
My lords, not only, my lords, she has other source of income, my lords. My lords, she has other source of income. My lords, my lords, I am taking care of the child, my lords. I'll produce documents, my lords, for that effect.
My lord, she's
Yes, my
drawing a
lords.
salary of more than 4.5 lakhs today. Great.
Serial number
What's
9.
up?
What are the other numbers?
It shall be tendered. For a part. CP and writ petition.
Serial number 9.
For the respondent, my lord. The copy is already served to the other side, my lord. The 9th. It's we have filed the vacating of the stay.
Who moved this memo?
So we have moved the memo.
You know, urgency?
We have urgency, my lord. We are respondent.
No representation for the petitioner. Ask the respondent is present. This is Martha tomorrow.
Yes, my lord.
Serial number 10.
The respondent in this matter, my lord.
My lord, I believe she has, the wife is shifted to Ahmedabad with her children. So last Saturday visitation rights was not successful.
The children have been admitted in schools in Ahmedabad because for the last 3 months she was unemployed. She has shifted just about 2 weeks ago because she has got a job in Ahmedabad in the month of in this month. No, there is no GNWC, man. There is no GNWC. He has only sought for visitation in this MC.
No, she has filed a petition for divorce. In that, an application for interim maintenance.
Father has not filed any GNWC till
No,
now.
no, no.
No, sought for only visitation rights.
There is no custody petition.
Then let it continue, whatever the court says.
That my only humble submission is, here is a petitioner who is earning about 4 lakhs a month. She is earning about 2 lakhs. The maintenance which was awarded is rightfully made only for the children. Educational expenses are also not borne by him, admittedly. And there are 2 children involved.
The last occasion he said so that we were there.
No, but that also they are not borne. That is just, they are only, yes, my lord. They are simply.
So that is not, if he says something, and court passes an order, it has to be implemented. Yes, what is the order?
My lord, the wife's petition for divorce, my lord.
No, there is no counter petition by the wife. We have not challenged the order by the trial court.
Yes, my lord. She has sought for interim maintenance of 1.5 lakhs, my lord, as per her application. And on the other hand, I have stated very clearly in my statement of objections, the income as well as the expenses that I am incurring. Your lordship may kindly come to page 87, my statement of objections filed before the trial court. Yes, my lord.
Ink page number 19.
36, my lord. Petitioner has produced a copy of her income. May I read, my lord?
So court has not passed any order to, with respect of the education expenses.
No, there is no specific order on the
I have been
educational
paying, my lord.
expenses.
I have been paying. Last year,
I wanted to know the court's query. I said there is no order for.
No, there is no specific order.
It's only with regard to the
maintenance.
maintenance. 30,000 and 50,000.
30,000 30,000 and 20,000, my lord. So totally monthly 50,000. What I respectfully submit is, like I made the submission the previous day, his income is 3 lakhs. That's why I requested your lordship to kindly come to my statement of objection that I have filed. It's very clear, my lord. At page 87, my lord, para 16. Hence, all the statements made by her are false and beyond imagination. I earn 2,90,000 per month. I have no other source for income. 16, my lord. Page number 87. Para 16 in this is the statement of objection that I have filed, clearly elaborating the income and expenses that I am incurring, my lord. Para 16, my lord. Hence, all the statements made by her are false and beyond imagination. I earn rupees 2,90,000 per month. I have no other source of income. I spent 33,000 EMI towards the house in which the petitioner is residing, 20,000 towards EMI of the car which is in my name, which she is using, 42,000 towards EMI of the house in Pune, 22,500 per month towards my present rental house. Thus, my minimum monthly commitment is 1,20,000. My other inevitable expenditure includes petrol, food, electricity, water bill, phone bill, internet, children's school fee, expenses to my mother and sister, and legal expenses come up to 80,000. Thus, my total monthly expenditure will be 2 lakh. Thus, I can save approximately less than 90,000, and I require that amount for any. It is joint one, but he is the only person who is paying the EMI. And also the maintenance charges.
I'm not getting any benefit out of that.
Yes, my lord. I had rented it out. She issues a notice from Bangalore and gets the tenant evicted. And she says she has no benefit. I had let it out for rent because I am paying the entire EMI for that property. She issues a legal notice from Bangalore and gets the tenant evicted. And
There's
here
no
says
proof
that
of
there is
eviction.
no.
I'm sorry. Yeah.
And says now that she has no benefit. My lord, this is all support, were made in support of the documents before the trial court. The bank statements were given, the EMI statements were given, everything were given, my lord. And by her own, in her assets and liabilities, my lord, she has stated that she is earning 2 lakhs, 2.5 lakhs.
They have filed it at, along with the petition, it's like in page number 105. 2,04,995 I have declared as my income. 105, my lord. 4,995 as on the date of filing only. Expenses, my lord, admittedly, 33,000 is the home loan which I am bearing towards the house. Yes.
Yes, ma'am. For that particular house in which she is residing with children.
With the children, I am residing there. Apart from that, all the expenses of the household, including the tuition fee of the children, bringing up nourishment, everything I am bearing. Only on certain occasions, some payments were directly made by him for the first child, not for the second child, for the tuition expenses. Only tuition expenses were borne. And if your lordship sees, there is a bank statement which I have produced along with my objection statement. It is a Citibank statement, admittedly of the petitioner. Apart from 4,26,000, which I have produced the income tax records, which also has been observed by the trial court, 4,26,600 is the salary that he is drawing. From that, there is a bonus of about 10 lakhs that he has received in that particular year. Year on year, his increments have happened. He has been promoted. He is in a better position. And I am told that presently he is drawing about 1 crore of rupees per annum as his income. Just to keep the children on par, we are not asking for the entire. The court has ordered a reasonable sum of 50,000. I have not challenged that at all before this court. School expenses. Now, as on last week, I have borne the school expenses of 1,05,223 for the first child. For the second child also, she is also in the UKG. So near about 1 lakh today, every school is charging that much for admission itself, my lord. One is 13 years, the other is 5.5 years.
Yes, madam.
You're talking about the home EMI.
Yes.
As well, he's also paying the same amount.
Yes.
The Pune house, you say you're paying the EMI.
Yes.
You rented it out and you're having the right to that.
No.
No, whatever the real estate circumstances, earlier that was a position.
Now there is no.
What is that exclusively you're spending, except this 20,000 of EMI which you're paying? What are the other things you're taking care of? And with the salary?
Last year, he paid the entire school fee of the first child, my lord.
Why not the sitting chair?
My lord, so much of burden, my lord, and that itself came up to 2 lakhs, my lord, last year. That and he's bearing so much of EMI. My lord, my submission was in the application, my lord, that I will share the school fee of both the children along with her because she is also earning. Yes, and I am ready to pay 5,000 per child towards the children's expenses. This is what I have submitted in my application objection.
What if it comes 50% of the school expense?
Yes.
50% of the school expenses.
50% will be for the elder one it's close to 4 for 2 full year.
About 2 lakh rupees per annum.
For the elder one.
With for the elder child, about 2 lakhs. Yes.
And for the elder one, 75, so full year will be 1.5.
About 1.5 lakhs.
So whatever it is.
Yes, my lord. A school fee ready to share 50%, my lord, of both the children. Because last year she did not give us the details. Therefore, however, since he continued to pay the fee of the elder child as he was paying from the beginning, so he could somehow make the online payment and made the entire year school fee of the first child. My lord, unnecessarily he's being burdened by the EMI on the car and the Pune house, my lord. No benefit, it's just locked. Let there be a settlement, ready for divorce, ready to bear 50% expenses on children's education, and some minimal amount for the welfare of the children. By then the EMI and all will be cleared. Let her sell the car, let Pune house be sold, and he is ready to give this house in the children's name. What more settlement, my lord?
The difficulty is here is a petitioner who has been alleged of having extramarital affairs. Admittedly, they transfer amounts to third party. In their own objection statement, they have stated that.
Yes.
And here they don't want to take care of the children's needs.
No, not that we'll not take.
be half of the school fees and 20,000.
No, my lord, 20,000 to,
10,000 each.
my lord, it might be difficult, my lord, because
that
now
would be
his
very-
rent, my lord, has increased to 28,000. No. No, but my lord, in the ordinary no, 1 minute, my lord, I know, yes, I understand. In the ordinary situation, yes, my lord. But he's paying the EMI of the car, which he is using, my lord. 20,000 per month for the car that she is using. Ma'am, my lord, it might be, and Pune house also he is not getting any benefit.
That we are not aware of.
Almost 2
That we are not
lakhs.
aware of, because for the last 3 years, they say it has remained vacant.
Yes, it has
Here is a
remained
case when
vacant.
2022, he deserts the entire family.
Whatever that today was, whatever it is, let him rent it out. And if you both of you fight and that is kept idle, what will happen? You expect him to pay the maintenance, pay the EMI, and keep the house vacant.
No, that house,
What I expect is, I don't want clients to come to the court and speak. This is not a family court.
no, I'm sorry. No, what is happening is the maintenance of the current house is also not borne. The CAM charges also I am bearing. Electricity, whatever is there, that is also being borne by me.
Then somebody is paying EMI. You should expect some, there should be some money in the out of it. It should be, at least they should give it for rent. They should.
No, that is left to him, my lord. We are not coming in the way at all.
Yes.
That we have not come in the way of that apartment at all.
The Pune house, he is at liberty to rent it out and have till further orders to be passed with the court with regard to the alimony or whatever it is. Till such time he'll be having the control, number one. Number two, he will pay half of the fees of the children and 20,000 towards their maintenance.
My lord, let her sell the car, my lord. That is again a burden to him, my lord. 20,000.
Now again,
EMI.
they want to bring more penury to me. Ultimately,
My
they.
lord, my lord, the car is in his name. Car is in his name, my lord.
MC number, IA number 3, 4 and 7 in MC number 2757 of 2023, dated 31st January 2025. The husband is before this court. By order impugned, the court had granted interim maintenance of an amount of rupees 30,000 to his first daughter and rupees 20,000 to the second daughter from 8/2/2024 till the disposal of the petition. Further, court has also allowed the father to visit the minor daughters on every first and third Saturday between 4 p.m. to 5 p.m. in the presence of the mother in the visitation room situated at 4th floor of the building. The wife had filed the MC seeking divorce. In that, the ISO filed IA number
4, my lord. For
IA number
maintenance.
4 is filed for interim maintenance. Is it?
4 is for maintenance.
IA number 4 is filed seeking interim maintenance, and IA number 3?
3 is filed by them for visitation.
Rights.
Visitation.
IA number 3 is filed seeking visitation. The wife had sought maintenance of an amount of rupees 1,50,000. The children are, both the daughters are aged about 13 and 5.5 years. And it's a case that husband is earning an amount of rupees.
As per the trial court, 4,26,600 as from the income tax records.
4,26,000.
600.
Before deduction of income tax, my lord.
And is not taking care of the interests of the children, and her income is 2,04,995, and it's a responsibility of the husband, father, to take care of the children. And as she is earning, she has not sought for any maintenance for herself. The court, considering the respective statements of assets and liabilities filed on behalf of both the parties, had granted maintenance of 30,000 and 20,000. And the court has observed that that the claim of 1,50,000 as maintenance is not reasonable.
Your Lordship, one submission, my lord. The present house right now is getting vacated. My only request is let me be permitted to rent that house because I am also staying in another rented accommodation in Ahmedabad. I may be permitted to rent that place and use that rental income towards the Ahmedabad house because
No, my lord, then
because we
he
have
can
been
stay, let him stay.
admittedly we
He is
are
also
residing there
residing.
and the EMI is also
What is
borne
that?
by us.
Now, they say that since they have shifted to Ahmedabad, the presently house in which they are residing, they want to rent it out. My lord, don't want my lord. Let him reside, my lord. He is also
Pay
paying.
another, the remaining amount.
My lord,
He will pay the rent, whatever it is.
no, he is now staying in the rented premises. My
That's what I'm saying.
lord. So if she is claiming the rent, my
Who will
lord,
pay the rent there,
which one, my lord?
where she's staying now?
My lord, suddenly she has gone to Ahmedabad for no reason.
It's
my
not
lord.
sudden, my lord. 3
For
months
no
she
reason.
was
She was
she was
here all
literally
along,
unemployed for 3
Bangalore.
months.
She wants
He
to.
wants to, if he wants to occupy that house, whatever that, now the court is saying now 20,000, you will not get an accommodation in 30,000. Let him pay that. Half of the school fees and this 20 plus 30, 50,000.
My lord, then at least car, my lord. Anyway, she is not residing here, my lord. She's going to Ahmedabad. Let her sell the car, my lord. At least that burden.
So they want to take the cherry and the cake and
No.
I don't understand. Here is a case
no,
where
what is happening to this car? Now she has left to Ahmedabad. She is taking the car to Ahmedabad.
she is going to take the vehicle because she wants to use it for the children's benefit. She is not using it for her personal gain. It's only for the children's welfare that she's kept the vehicle.
Vehicle is in
And
his
by his
name.
consent, they have left it.
Vehicle is in his name. He is paying the EMI from day one. Now I would
No,
like
what
to.
is the difficulty? It's for your children.
No, this is a burden, my lord. 20 lakhs, 20,000 per month on the
No,
car.
As
for
far
the-
as, no, that issue this court is not going to, with regard to the house which she is going to vacate. And if your client wants to occupy that house, let him tell what is that he is going to pay. Now the court has already said 50% of the expenses and 20,000. What else would be the additional amount? Then you will be permitted to occupy the job.
No, he gives up, my lord. He gives up. But Pune house, my lord, let them not interfere. He'll get some
Let them
rent.
record. I told
Yes,
you that I
and even,
record.
my lord, I request car also, my lord. It is absolutely, it's a dead investment. She is using the car.
He doesn't have a car.
Yes, no, he had to take a car.
Then what about the children?
Again-
Children, they don't require any.
No, my lord,
facility.
she files cases after cases. She has filed a petition before
Not going
domestic
anywhere.
violence.
Please leave it
That's a
there.
matter of
Yes.
trial.
Yes.
They don't come there. They don't appear before the court.
By considering the educational qualification, their employment and income, stay of the wife and the daughters in the apartment jointly owned by the parties, comma, stay of the husband in the rented house and responsibilities of the parties, payment made by the father towards education of his first child, age of the children. The court had granted the maintenance of 30,000 to the elder child and 20,000 to the younger child and granted the visitation. Next paragraph. When counsel appearing for the petitioner submits that the income of the petitioner is 2,90,000. Out of that, he is spending an amount
It's
of
4 lakhs, my lord. Petitioner.
2,90,000, and out of that, 33,000 is spending towards the EMI in the house where the wife is staying. 20,000 towards the car loan which the wife is using. 22,500 towards a property which is situated in Pune, which is jointly owned by them. And he is already spending an amount of rupees 1,20,000, and 80,000 he requires towards his expenses, and is hardly left with 90,000, which he required for the for any emergency. It is submitted that the wife is equally earning, and her income is 2,04,995. Land council submits that the father is ready to pay the 50% of the educational expenses, and the amount of 20,000 plus 30,000, that is 50,000 granted by the court, is on the higher side, and the petitioner is not in a position to pay the said amount. It is submitted that the house in Pune, where he is paying EMI, when he has rented it out to a tenant, the wife has issued a notice and made him to vacate the house. Land council submits that he had to pay the EMI to the Pune house, and he is not getting any income out of that. And further, he is also paying the car loan for the car which the wife is using. On the last occasion when this matter came up, it is submitted that in spite of doing all this, the father is not permitted to see the children. Then this court has adjourned the matter to this day and passed an order that the visitation shall go on Saturday. It is submitted that as per the order passed by this court, the visitation went on well. It is, Land council submits.
My lord, last Saturday they did not meet. My lord.
No, children, we have not,
They
we have
didn't
not
meet.
visited because they are in Ahmedabad, my lord. Practically they are.
Only once, my lord.
What
She
is the
Children are
order
there.
What is the order of the court?
No, that's what we could not, the reason is we could not bring the children. They are in school, my lord. They're already admitted. So we could not have the.
Saturday also they go to school?
No, because.
You bring to the notice of the court that they are not in Bangalore?
No, I was not aware because I had no instructions on the last hearing date, which was came up.
Yes, so you said that the investigation went on well.
No, my lord, they didn't come.
And what is the sanctity of the order of the court?
My lord, only once she brought, and that too.
No.
Where is your, you have filed any affidavit before the court for not complying with the order? Why you are not complying?
No, the difficulty is it was listed last week. I got instructions only 4 days ago that the children they had their education. They have been
Whatever
admitted
it
there.
is, first of all, when there is an order of visitation, you don't comply with that order. Then again, the court will pass an order, and your client, she doesn't even. Then what? That's what it shows. What respect
We have
she has for the
communicated
order.
to them. In
What
fact,
is
we have
then I'll
communicated.
suspend this order. I'll suspend this order. Let her face it, because she can't. This is not the way court expects a client to behave.
No, the difficulty
No,
is,
I'll
my lord,
suspend this order.
they were not
Let
having.
it be.
they-
No, she's getting 2 lakh rupees. Let her enjoy.
The children were
Passed by this court.
the
No,
education
will
also
not.
was discontinued, my lord. They
Let
had to
them
be
do, let
hurried
them
there
do.
and they have been admitted there. my lord.
I'm making it very clear. Clients cannot take, it's not there at their will and wish, they will not imply.
No,
the court
though an
orders
order
need
was
not be
passed,
complied.
I made it a point to communicate to the other side about the visitation also. my lord.
No.
This was communicated
I
straight
will
away.
suspend this order. No, I will suspend this order.
My request is, lot of hardship will be caused because there are 2 children involved.
You want an order from the court, and at the same time, you don't even comply with the court order. What is that? What are these double standards? I've already observed it on the last time. In spite of that, your client it still comes to the court without complying with the orders of the court. I'll suspend it. Let it, you please
request,
take
my lord,
care of it
because-
at later point of time. Whatever you want to do, you do.
Because here the question of visitation was not under challenge, my lord. They only challenged the maintenance
Compliance
order.
of the orders.
No,
is-
I'm not on that. I'm not on that at all. My request is,
I will, no, then what we do is, I will only stay the order of maintenance. Let that order of visitation be open. I'll not, anyhow, because you have not questioned it, let it be there. They will file an execution for that.
Contempt.
no, that I will have to file a modification application. That I'll approach the court because there are changed circumstances now.
Yes.
That's my only request. It's
Then
not like,
suspend it.
it's not that we have never brought the children for visitation.
What is
Twice
the-
there was an
Okay,
attempt
I
for,
think- Please read the order passed by this court.
unfortunately, it has not been uploaded also, my lord. I could not.
It's not
difficulty.
uploaded. When is it not, when is this
I
order
checked the
passed?
order even this morning, my lord.
Why is it not uploaded, signed long back? Look at it. I think you were there very much in the court.
I was there, my lord. I was there. I'm not on that at all, my lord.
What the court said, according to the land counsel appearing for the respondent mother, husband himself had left the house, and the allegation that he has been thrown out of the house is not correct. When the court passes an order of maintenance, and if the court also passes an order of visitation, the party cannot be expected to fulfill or comply with the order which is acceptable to them, and the other order they can't afford not to comply with the same.
I'm aware of that order, my lord. I'm not on that at all.
Come.
My request is,
The order dated, the family court had passed an order in I number 3, 4, and 7. I was under the impression that you said it went on.
No, my lord.
In MC number 2757 of 2023, dated 31st January 2025.
Not even single day she has brought.
no. This is a wrong
Only
submission.
once, only once.
Please.
Yes.
This matter
The wrong
came up before
submission.
the
They have
court
not
on
challenged that order at all.
6/2025. And this court had passed an order wherein the court has specifically observed that when two orders are passed in the by way of the impugned order, whereby the visitation is granted and the maintenance is given to the wife. The wife, the party cannot be expected to fulfill or comply with the order which is acceptable to them, and the other they can't afford to not comply with the same. Then this court had directed the matter to be listed on 23/6/2025. Basing on the visitation on Saturday, further orders will be passed. As it is brought to the notice of the court that the order of visitation is not complied with, then basing today this court the court is proposing to dispose of the matter. At that point of time, it is brought to the notice of the court that the children who were in Bangalore were recently shifted to Gujarat, to Ahmedabad, and the order that is passed by the court also is not complied with.
Due to their schooling, they were shifted, my lord.
Is not complied with. It clearly shows that the respondent wife has no respect to the orders of the court, and this is not and blatantly she is violating the orders of the court. In that view of the matter, the order passed by the family court as far as I number 4 is concerned is stayed until further orders.
Difficulties, the children are there, my lord. It's only for their education that they have gone there, my lord. It's not, the intent is not to violate the orders of this court.
Yes. Next. Give a date after a month. Objections are taken on the court. Yes.
For petition.
Take out that. 1 of 25.
Third application for the paper publication.
Why it is not uploaded? Why the orders are not uploaded after the signing it? Whose order is that? Who has taken? Find out.
But application filed, my lord, for the substituted service, my lord.
What had happened the earlier occasions?
My lord, order passed by the Supreme Court, my lord, with regard to the substituted service of the
No,
notice.
that I understand. I'm asking you what has happened on the first and second occasion.
My lord, three occasions, my lord, the notice has been gone, my lord. He has not taken the notice. Remained
Not
unserved.
covered, returned with postal shara as a respondent. The so and so is filed. Taking out notice by way of substituted service. So accordingly, I number so and so is allowed. Please be permitted to take out notice on respondent in so and so on or before, mentioning the date of hearing as so and so. Yes, next.
Annexure C1 is the impugned order passed in execution number 13/22. The petitioner is the husband, the respondent is the wife. They married in the year 2011. After 3 years, the relationship between the became marital life became worse. Then she deserted along with child. Not the order passed is under section and in execution case in page 37 is the order. Plus she has deserted the petitioner She is living in an adulterous life with one Bharat of the same village, openly.
Come to the impugned order. Let us see the impugned order. Please read it.
Impugned
Then
order
you can
is
submit.
annexed here, C1 in page 37, passed in execution number 13 of 22. That the court order passes the order directing the petitioner to pay rupees 4,000 per month as litigation expenses. It is not a maintenance, litigation expenses. And subsequently, the very case filed by the petitioner seeking to divorce came to be dismissed for non-prosecution.
Please read the order.
I will read, it start from in page 40. Sorry. The present petition is filed by a decree holder in MC number 98 of 19, seeking enforcement of interim order under section 24 of HM Act. To the said application, the JDR has filed objection with regard to maintainability. It is contended that the petition is not maintainable on the ground that MC number 98 is not pending, and the same has been dismissed for default. It is contended that the petition is not maintainable and the JDR is not entitled to any relief. It is contended that the petition is not maintainable either in law or on facts. It is contended that the petition is liable to be dismissed in layman. Hence, it is prayed that the petition is to be dismissed as prayed for. Heard so and so. I have considered the argument put forth by both sides. A perusal of the petition shows that MC number 98 of 19 was disposed of on 9/6/22. The maintenance amount, this is not maintenance, it's litigation actually. By wrongly it is mentioned as maintenance amount. The claimed is for the period commencing from 6/11/2019 to 9/6/2022, when the petition came to be dismissed. A perusal of the order under execution shows that IA2 that was filed by the decree holder was allowed in part, and the petitioner in MC number 98 of 19 was directed to pay rupees 4,000 per month towards litigation expenses from the date of petition till disposal of the case. Here it is seen that the JDR has not contended that the order of this court has been challenged before the appellate authority, and the same has been set aside. In the absence of an order reversing the order passed on IA number 2, the petitioner is liable to comply with the order dated 8/3/22. Merely because the petition came to be dismissed on any ground, it cannot be held that the respondent is absolved of his liability with comply with the order of this court from the date of the petition till disposal. Hence, it is clear that the petition is maintainable and the objection filed by the JDR is not maintainable. Issue attachment warrant of movables of JDR.
Yes. So what is wrong with this order?
This the petitioner has filed that earlier petition filed for seeking divorce came to be dismissed for non-prescription. And firstly, after service of some summons, in the MC case MT number 91 of 22, sorry, 98 of 19, she remained absent. She did not contest the matter. Thereafterwards, she appeared and filed an application under section 24 seeking maintenance, but court ordered litigation expenses. Thereafterwards, the petitioner has filed another case seeking for divorce. That is MC number 98. Sorry. In the year 2022, he has filed 91 of 22. In this petition, he has prayed to produce this as Annexure D.
Had granted litigation expenses for 4,000 per month. That is between, according to you, on 9/6/2022, it is dismissed for default.
Yes.
So, from 6/11/2019 to 19/6/2022, why is she not entitled? Whatever is the reason.
Because she has deserted the petitioner.
Those are not the grounds.
Here,
If that is the ground, you should have questioned it.
recent developments I wanted to submit before the court. Recently, she has sent word through some others. She is ready for settlement because she is residing with somebody leading adulterous life. She has taken child also openly and publicly, and she has put this status in the Facebook. She is living with him. How can this petitioner tolerate? Therefore, she has sent a word through somebody. She is ready for settlement. So we will settle it. Let her come before the court. Let her make a statement whether she is willing to continue with the other person leading adulterous or not. Let her make a statement. Simply, the petitioner has been made to pay the litigation expenses. She has not discharged her marital obligations. He deserted the petitioner
Yes.
without there being any allegation against him.
Earlier petition which was filed, it had been disposed of for default. They had not appeared, Your Lordship. In that, this IA2 was allowed, and they have not contested that petition which was filed for cruelty. Again, second time they filed a MC case on the grounds of same cruelty and as well as desertion, Your Lordship. And it has come very clearly in the order at page 30 that from before filing of this petition in the year 2019, prior to that, 2 years prior to that, from then he has not been paying any maintenance. The petitioner has not stated about his occupation and his earnings. He has clearly stated that his minor son is in the custody of the respondent, Your Lordship.
The order
And
passed
that is
in
not giving.
execution 13 of 22, dated 17/12/2022. The JDR husband is before this court. The court in I number 2 in MC number 98 of 2019 had passed an order whereby the husband is directed to pay rupees 4,000 per month to the wife to his litigation expenses from the date of petition till disposal of the case. On the petition was on 6/11/2019 and later that came to be dismissed for non-prosecution on 9/6/2022. Now the present execution is filed seeking the amount, seeking recovery of an amount of rupees 4,000 between 9/6/2022 from 6/11/2019 to 9/6/2022. The court has observed that till 9/6/2022, when the matter is, when MC is disposed of, till such time, the wife is entitled for the litigation expenses of 4,000 as the husband has failed to question the said order passed with the family court and accordingly allowed this application by issuing the attachment of mobiles of the JDR if steps taken by 31/2023. Assigning the same, when this petition is filed, an order was stay was granted on 29/1/2024 on the condition that an amount of rupees 50,000 shall be deposited before the court before this court by the next date of hearing.
That is deposited.
And the said order of the court is complied with. Land counsel appearing for the petitioner JDR submits that wife had deserted the husband. She is living an adulterous life, and in those circumstances, the husband is not liable to pay this maintenance. It is submitted that there is a scope for settlement. If the time is granted, they will settle this matter. It is submitted that thereafter, in the year 2022, another MC is filed. It is pending consideration.
It is pending. Notice is ordered.
It is pending consideration. Next para. Then counsel appearing for the respondent submits that no amount is paid to her except this 50,000 which is deposited before the court. Further, when the order that is passed by the court is not questioned, fixing 4,000 as maintenance. It is not
Litigation expenses, it's not maintenance. Litigation
expenses of 4,000. It is not open for the husband to raise that ground now. Further, during the pendency of the MC, till the date is 19 to something, the wife is entitled for the litigation expenses, and the court had rightly ordered the petition. It is submitted that as stated by the petitioner, there is no scope for settlement. Next para. Having heard the counsels on either side, there is a material on record. This court is concerned only with the order impugned and what is the illegality with the said order. The court, while passing this order, has passed a reasoned order giving the detailed reasons in such an order. The admitted facts in this case are that an order was passed granting litigation expenses of rupees 4,000. That order has attained finality as it was not, and it was not questioned. Admittedly, on 19 so and so, the MC was dismissed for non-prosecution. From the date of the order till said date, the wife is entitled for the litigation expenses at 4,000 per month.
Your Lordship, from the date
That
of
is
the petition,
excessive.
from the date of the petition, 28/10/2009.
That is excessive. In a month, there'll be one hearing, that's
There
all.
in the order that she
Per
will-
month, litigation
from the
expenses
so-and-so,
cannot
she
be
is
up to
entitled.
4,000 rupees. At
Why
least-
you have not questioned that order?
That is it. Of course.
What you can't do in, otherwise now you can't do it in the execution again, is arising out of an execution. What do you write? 4,000 per month. The all other submissions which the husband, the learned counsel appearing for the husband submits, they cannot be considered, which is beyond the scope of this writ petition. This court do not find any illegality with the order that is passed by the executing court.
Almost, he has also filed review petition, that is also pending. Review.
Accordingly, the writ petition is dismissed. Amount in deposit shall be forthwith transferred to the executing court.
Regarding, but she has sent word to somebody, she is ready for the settlement because she has no face to join her husband, having deserted him, having been leading the adulterous life.
If there is a scope, you please explore.
But now again, she will not come forward because if the order is as per this order, she will not. The patient will have to suffer throughout his life,
Yes.
seeing her adulterous life.
Yes, next.
Application is by seeking amendment of prior merger. Initially, RPFC is filed, sought permission to convert it for a WP. FC.
You said that you didn't ask for the interim order.
Yes, madam. Interim order was not there in the writ petition. So that's why
You submitted that. Initially, RPFC was filed, and later, the petition, it was converted into a petition, and out of oversight, they have not sought for an IA seeking the stay. And as such, the present IA number 3 of 25 is filed, seeking the said amendment. Accordingly, the amendment petition is allowed.
I may be permitted to amend the petition.
The petition shall carry out the necessary amendment to the cost item.
Matter may be posted next week somewhere, minutes for admission.
Tuesday.
Much obliged.
Yes, next. Putting you appear. Morning, somebody informs me that they already informed you. I recorded that also. Look at it. If it is what it is, list it tomorrow. If I've recorded that it is informed to the other side, now we record that. Look at it. 14. I think in this matter they have given NOC, respondent. They want to file a memo of retirement. That's why it is adjourned.
For the petitioner, 15. In fact, the respondent has not complied with the order of this honorable court.
What is the order of this
On
court?
20th/3/2024.
Filed an affidavit, learned counsel petition by submitter, it come up with objections. Pending arrears should be deposited. No further time will be granted. You are for the wife.
I am for the wife, my lord. The second petition is filed by the husband.
List learned counsel appearing for the wife is present. No representation for the counsel appearing for the husband. List WP 27630 of 2023. That's the husband's petition.
Husband's petition.
For dismissal tomorrow. Next. Yes. 16, no representation. Next week.
Yes, Miller. I prepared this writ petition only to modify the impugn order, Miller. Your Lordship,
What is the impugn order? Where is it?
I would like to take my Lordship to ink page 28 and 29.
Hmm.
Wherein, my lord, the trial court pass,
You are for wife or husband?
I am for the, my lord,
You are for the wife or husband?
wife, my lord.
Hmm.
Here, my lord, can you see, while allowing IA number 4, filed under section 26 by my husband, the trial court passed the following order. The respondent father is permitted to take the child, Kumari Naira M, on fortnight Sundays, that is, first and third Sundays of every month, by picking up the minor child from the house of the petitioner at 10 a.m. and dropping the child in the evening at 5 p.m. on the same day to the house of the petitioner. My lord, without accompanying of the mother, my lord, the child cannot go,
What
but
is the
to
age?
on Sunday.
Age.
My lord,
Age of the child.
age of the child is, my lord, 2.5 or 3.5 years. She is school going, my lord. Sunday, my lord, kindly see, if she spent with with her father entire day, how she will prepare to go next morning, Monday to the school, my lord.
Let it be Saturday.
That's what, my lord, I made. I would like to take my lordship to my prayer.
What we do, because it is coming up for the first time,
Ink page,
we'll make it a Saturday, let them come.
my lord, one 15, page number 15, please.
Yes.
15, prayer B, my lord. Or otherwise, my lord, page number 14, para 15, my lord. I would, my lord, kindly permit to read the pleadings made by me in para 15. Please, my lord. It is submitted that petitioner left with no other option.
Well, the court must have, when the court had passed this order, court must have interacted with the child and looking at the manner in which the boy is comfortable, the court might have passed the order. Please come to the order. Where is it recorded about the interaction and other things? She's 5 years old.
Yes, my lord.
Not 3.5.
Yeah. No, what
I personally come to page number 10. I personally interacted.
Yes, ma'am.
Please read it.
It is there.
Let's read. Let's read.
Being a father and a daughter, it is
Please
there.
read.
When we produced the word before the court, that court was observed that our prayer is, my lord, to modify the order by allowing this writ petition and modifying the impugn order.
For anything,
Mother is required to accompany with her in the third floor of the Nyaya Devgala building.
You want it to be in the court? No. That visitation in the court unless and until compelling circumstances.
Convenience has been made by the court itself.
Interact with the child. The child interact with the respondent father very well. He has shown her photographs and other photographs in the mobile. Interestingly, saw the photographs and answered all questions posed by him. What can be done now is as a way of an interim order. Instead of Saturday, we can say it as a Sunday. And remaining other things are open. Let the mother come, we will see.
Along with mother. Because
only if you want, if you want an ex parte order, it is Saturday. If not, please take out notice. Then we will see on the 4th. Now, if you want modification.
My lord, the great difficulty of the child is, my lord, she is a female. And mother has to be accompanied with, my lord.
If it is child's difficulty, court wants to understand. Mother's difficulty, court can't understand.
No, mother has to accompany with the child.
When the girl is comfortable, you have to tell one reason why she shouldn't be alone with the father. There should be some reason.
Correct, my lord. It is their inconvenience because the mother is apprehending.
What?
Because the husband is not good terms with the mother. They may do anything to the, ward. That is the apprehension.
That's what I said. Now, either it is Saturday, now itself I'll modify in the meantime, or you want it mother to be accompanied. For that, we need their presence.
May not kindly permit mother to accompany with the child.
That's what I'm saying. Now I will not pass that order.
Yes,
if you want, I can only pass instead of Saturday. I'll make Sunday. I'll make it Saturday.
Yes, madam. I will file another application before the trial court to see mother has to be accompanied with the child.
I think am I clear?
కష్టమైతుంది స్వామి ఎందుకంటే చాలా కష్టమైపోతుంది బిడ్డకి.
No, I made it very clear.
He is a female child.
No. If you want it
Saturdays.
that way, I'll grant it, or
Night-
else we take out notice.
Night they will put some payment. There is a accommodation made by the, trial court for this
To take
purpose.
out notice on the counsel appearing for the respondent before the trial court. If you want it, I'll adjourn it, we'll hear it. Otherwise, I'll modify it to the extent of Saturday.
He's contested the case. Respondent is contested the case before the trial court.
That's why without
Who
notice.
filed
we will-
IA number 4 on section 26.
What do you want?
Leave it to the court, madam, because it is the problem of the,
That I will not, that I will not grant. The petition is permitted to take out notice on the counsel appearing for the respondent before the trial court and shall file a memo to that effect. Immediately after the memo is filed, list the matter.
and my lord, can you stay the further proceedings, please? Madam?
What further proceedings to be stayed?
Because he is insisting he is going to police station and my lord, he want to take away the child.
Yes.
18.
But then my lord kindly pass an order on first Saturday and third Saturday. Stay.
The mother is before this court questioning the order passed by the family court wherein the court had granted custody of the child on first and third Sundays of every month, whereby the father was permitted to pick up the child from the house of the mother at 10 a.m. and drop the child in the evening at 5 p.m. on the same day. When counsel appearing for the petitioner submits that the girl's age is 5 years, and as both the parents were not keeping in good terms, without there being any without a supervision, granting visitation was not correct. Further, it is submitted that if the girl is on a Sunday, if she spends the entire Sunday with the father, she has to get ready for her school the next day, which will be difficult. Next para. As far as the first prayer, the first submission is concerned, that is with regard to the Saturday and Sunday, this court is inclined to modify the order of the family court from first Sunday and third Sunday to first Saturday to third Sunday pending third Saturday pending disposal of this petition. However, the second submission is concerned, this court has perused the order passed by the court, wherein the court had recorded that how comfortable the girl is with the father. Unless and until compelling circumstances are brought to the notice of the court in normal circumstances will not pass any order that there should be a supervised visitation or whatever the submission of the mother is, to consider the said plea, the presence of the parties, the presence of the other side is very much required. Hence, this court is passing the following order. Number one, the family court's order that on fortnight Sunday, and that is first and third Sunday of every month, is modified to first Saturday and third Saturday of every month, and the other clauses in the other part of the order remains to be the same. Number two, the father is permitted, the counsel appearing for the mother is permitted to take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect. Immediately after the memo is filed, the case shall be listed.
18. Srinivas Manohar Kulkarni.
One submission with regard to serial number 16. I was held up in the adjacent court on my lord. However, there is no one appearing from the response. There is an interim order in my favor. Kindly, it may be extended. Serial number 16, my lord.
Why nobody is appearing? Have you taken out hand summons?
Hand summons carried out. I filed a memo with regard to that effect.
16. What happened?
No representation. I was held in
Can
this.
you, interim order, notice to respondent is awaited or served?
Served. Hand summons served to
Notice to
trial court.
respondent, hand summons are served. And the interim order earlier granted is extended until further orders. List this matter. Somewhere give the date in July, 15th or 16th. Yes.
Obliged, my lord.
Petitioner in this matter.
18.
Her petitioner is the wife. She has filed a MC petition against the respondent herein, seeking for divorce. Along with the petition, an application was filed for interim maintenance, which was number.
Is granted.
No, nothing is granted. The court says the difference between their salaries is very less. There is no need to grant any.
Notice.
19. KK Vasant.
My lord, I am appearing for caveat respondent in this matter, my lord. My name is not shown.
Copy is
They
served
have
on you.
said the copy. Yes, please, Your Honor.
His name
Kindly
may
I
be
pray
shown
for
as
time to file objection.
That caveat in MFA. Even then, I have actually served copy showing that this is the petition is maintainable. I received the copy. His name is.
Copy is served, my lord.
Yes, what is it?
I kindly pray
Naveen.
for a week's time to file objection.
Not required. Caveator
Please, sir.
giving you a copy is sufficient.
Please, Your Honor.
Yes.
Naveen Santosh.
What is impugned order?
Well, the impugned order is the petitioner is the wife. She has filed the
Page
petition,
number.
page number.
72, my lord. Annexure.
75.
The respondent is directed to pay educational expenses of their son.
Lord, that is the thing they have said.
Huh?
Because the petitioner could not produce any document to show his the source of earning per month. The trial court is directed to pay him only school fee of the child. The child is
Not school fees, my lord. Entire education expenses.
What is the salary? Your salary?
My salary, I don't have any salary, my lord.
What is his salary?
His salary is now I have sent 75,000 per month.
What
But
are the educational expenses?
The child education expenses per month, 10,000 rupees tuition fee have to be paid.
10,000 is the educational expense.
Yes. Now, this year I don't know, but last year they have paid 10,000 rupees per month as a tuition fee in addition to development charges.
Yes, yes, Mr. Counsel.
And now,
My lord,
your
till
last
now they have not, my lord, till now they have not produced
So
any.
the wife is seeking enhancement.
Yes,
Wife is
but
seeking.
nothing is, so far maintenance of the child is a
So
spastic
then it
child.
has to be finally heard.
Pardon, yes.
Please.
The objection, then counsel for the respondent. Caveator seeks time to file objections. This is matter after 15 days.
My lord, his name may be ordered to be shown.
Write it, print the name as so-and-so, so-and-so for the respondent. Next.
20. SR Shri Prasad.
Divorce petition, your wife files the application IA2 seeking maintenance in the sum of rupees 25,000. Or 5,000 is ordered.
The seeking enhancement.
Please.
Notice.
No.
Oh.
I'm just challenging the order, granting 5,000 rupees maintenance.
Also.
Please.
Why?
Reason is, my lord, I'll just take the impugned order at page number 8, page number 17, paragraph 11. Internal page 8, paragraph 11.
Please read.
The affidavit of assets and liabilities, the respondent provides that she is BBA and MBA degree holder, but not employed. Her general monthly expenses is 25,000. She is residing in a matrimonial home along with the petitioner. She stays with me, Lord. She is with me right now also. Lord, then she filed, after filing this, she files 498A proceedings against me as well as my mother. All she wanted is to give the house where we are residing to her. This is her intention. Now, Lord, she was working in Thrissur Engineering as an accountant, and she left the job, and then she claims maintenance. Whereas, Lord, the petitioner, he was an engineer working. Now he is removed from service.
When
He was removed on 11/10/2023. My Lord will find at page number 18.
order,
Please,
when is this order?
Lord.
When is the impugned order?
Impugned order, Lord, it
This
was
is
passed on
19th October. Was it
19/10/20.
not brought to the notice of the court?
It was not. No, it was brought to the notice of the court. It is there, Lord, page number 18. Page number 18. First
Yes.
line, Lord.
11/10/2023.
He resigned his job as senior executive assistant. By relying on this document, the petitioner claims that he lost his employment not capable to pay the maintenance and litigation expenses claimed by the respondent. Respondent has not filed any document to counter the relieving letter filed by the petitioner. Therefore, it could be inferred that both petitioner and respondent are substantially qualified.
This is not a case to be stayed at for 5,000 rupees. Notice.
Lord, what has happened is, Lord, she is staying with me and she is claiming maintenance. Lord, added to that, Lord, she files a 498A proceeding to see that the parents are sent out of the house. Therefore, my Lord, conditional order, my Lord, I am ready, my Lord.
What conditional order?
50%, Lord, I'll deposit.
Yes, the land counsel for the petitioner submits that he has lost his job. That fact was not considered by the court. And the wife staying along with the husband has even filed a case under 498A to see that the parents are thrown out of the house. He submits that, having observed that he is no more working, still the court had granted maintenance, considering the same half of the amount, arrears also at half, 8 weeks. Yes, next.
21.
Great.
Arun Govindraj.
Morning, they sought for time.
Sorry, Milord.
They sought for time responding.
Milord, they have also filed a writ petition 14355 listed on this Friday, 27th date given, madam.
Let this also go with that. List this matter on Friday along with so and so, so and so. In which one? You filed wakalat. What is the name? So and so, write the name. Submits that they've already filed the wakalat. Registry is directed up in the name. Yes, next.
22.
List on so and so along with on Friday. Yes, 22.
Deepa J.
Lords, this is an order being challenged on IA 22. May I request? May I submit the order of this honorable court? Unfortunately, the writ petition it missed. My lords, this is the same case where the father used to travel from Hyderabad to Bangalore, and this court, over the period of time, first it was for few hours, and later extended for one whole day, and then overnight was granted. If your lords may kindly have the order that I have produced before your lordships. Your lordships itself have granted the permission and liberty to the petitioner father to file for an application before the trial court for overnight. Your lords will have that at page 8, my lords, of your lordship's order. At the bottom, Roman number 7, my lords. As far as the overnight custody of the boy and vacations are concerned, the father is at liberty to move an appropriate application before the court. My lords, your lords also made an observation at page 9 in Roman number 9. This interim arrangement, because your lordships had given 1 day overnight here. This interim arrangement with regard to the overnight stay of the boy on 27/2024 is only considering the fact that the grandmother is coming to Bangalore. The court shall decide the application for overnight custody if at all filed independently, notwithstanding the fact that the order is passed by this court granting overnight. My lords, thereafter, there were 2 applications which were to be decided on. One was visitation, which was an overnight custody in terms of summer, winter, and vacations. That was allowed by the family court, but overnight was not granted. And thereafter, I moved before this honorable court, and this honorable court granted me overnights for 3 days in Diwali. Then I also had my 40th birthday in Hyderabad, which was a celebration. This honorable court granted me to take the child to Hyderabad 2 days.
Order.
My lords, if your lords may kindly have, Annexure A is the impugned order, my lords. I'll only read 2 paragraphs of the impugned order. Here I have overnight, I have weekend visitations on the 1st, 2nd, and 3rd Saturday, Sunday, my lords. I only sought for making it overnight, and I will pick the child after the school because the child was going to daycare center. I'll pick the child after the daycare center. My lords, may I request your lords? My lords, the father has spent more than 50 overnights, my lords.
That's
this
true,
summer,
but this court will not pass any ex parte orders in this custody matters. Let the other side be here. You take out handsome ones on the counsel for the respondent.
I shall
And
do, my
once the
lords.
move, once you file a memo, then the matter will be listed. Because we cannot, because the keeps on changing. We don't know if the court had interacted a year back or 6 months back, it won't remain the same
No,
today.
my lords, they just finished the 50th day of overnights, just ended on 9th of June. Until 9th of June, the father had the overnight as well during the summer vacation.
So we'll hear both of
My
them.
lords,
and then-
I will take the hand summons today only. If your lordships may kindly list this on next Monday at
Yes,
least.
whenever the notice is served on them.
My lords, today I'll serve them, my
Petitioner
lords.
is permitted to take out hand summons on the counsel appearing with the respondent and shall file a memo to that effect. Immediately after the memo is filed, list the matter.
My lords, one submission if I could make. My lords, the child is wanting to talk to the father every day because the bond between the father and the,
That we can, when both.
at least
when all
video
of you-
call, my lords.
We will not, because this is it's an old case where you're exercising the visitation, you're
Continuous
enjoying
visitation.
it. Problem in this case is both of them want to, like pulling it too hard and harsh, which is not good for them or to the child. Too much of indulgence every time and giving them the liberty to, and it still father wants more and more.
No, my lords, your lordships had granted us liberty. The trial court passed an order.
Just because the liberty is given every time, you
Yes,
cannot.
no,
ask
my
for
lords,
it.
if your lords, I'll only read one paragraph from the order.
Even if I feel that it is wrong also, without their presence, I'll not pass any order. Please ask them, please serve the notice, we will see.
Much obliged, ma'am.
Yes, 23.
Serial number 23, Mr. Kumara.
Yes, what is the urgency in this?
Last time, the court directed it to file assets and liability, we have filed it. And I have challenged the impugned order of passed by the London Family Court minute. What has happened here, unfortunately, Lordship, internal page number 43, there was earlier, wife has filed a petition under domestic violence section 12.
Will list this matter 2 weeks.
Obliged.
Huh? Huh? Stay is there. Stay is there.
No, there is a modified order passed by after hearing both the parties. And the interim maintenance was granted, it was modified. It was on the air. That is all. And
You have paid it?
that we have been paying it. That arrears was there, that has been
But
paid.
show the, how you paid it. Please give me that.
The orders passed by this honorable court in modification to deposit the arrears before the trial court we have paid, I have filed a memo also. He wanted a memo without hesitation, we have filed it. And what has happened, then the court has heard this matter and filed for assets and liability to hear on the merits on the matter.
No. What about that modification of the interim order and whether the amount is deposited or not?
The amount is deposited, my lord. I filed I filed a memo, my lord.
Where is the memo?
That
Look at it.
arrears is there, my lord. No.
Have you given him a copy of the memo?
Yes, arrears of memo, we filed it having deposited. It is there in the part of the proceedings.
1 minute.
Memo date.
Memo date, I'll find out.
1 minute.
Execution.
What was the modification order?
My lord.
How much was directed to be paid?
My lord, modification order, my lord, that order was passed, my lord, on 20, its lordship, I'll just read it, my lord. On 21/2/2018, the petition commit submits that the served a notice, Sriram Reddy, London Council responded before trial court, and the memo in that regard has been filed. Further respondent has also been served. to London counsel for the petition has filed a memo stating that demand draft of bearing number so and so dated on 31 to the sum of rupees 2 lakhs drawn in Access Bank of Limited has been deposited before the trial court on 31/1/2018. Office to verify whether the advocate has filed a wakalatama on the behalf of the respondent and also to show the name of Sri Ram Reddy as a counsel for respondent.
Deposited that amount.
Yes. 2 lakhs has been paid. I have also said I have no objection to draw arrears.
No, that you have paid from there till now. 2018 is the order, we have
That is
25.
what happened, my lord, that 5,000 rupees was reduced. And the amount was which reduced, then they said to deposit directly to the accounts of the mother. No, the children, it is on the mother's name to be deposited. That's what the order. It is to the our account. It has been passed. That's what been going on.
How it is going on, how much you have paid. According to them, they have not received anything. That's what they are saying. You can file a memo when you're saying that you have been paying right from 2018 till now. Apart from this 2 lakh, you're paying 5,000 every month according to you.
Then this. No. My friend is a little confused, my lord. This matter has to be aided and merits. What has happened? I have challenged the impugned order.
No, let's before going into that.
Yes, my lord.
Petitioner counsel submits that in compliance of the interim order passed by this court, maintenance amount shall be deposited with the bank account of respondent regularly. That's what is that amount? What was awarded by the family court?
That is modified, my lord. No.
Why will the court modify?
It is modified, my lord.
Why it is stated, it is noted that in criminal miscellaneous number, it is the respondent wife who has filed the application and not the children. However, the family court has ordered maintenance of 7,500 each to the daughters by ignoring the fact that in the settlement arrived at before the mediation center, a sum of rupees 15,000 per month is already being paid by the petitioner herein. Where is that? On that, the court had granted stay. So first of all, you have to show to this court. And as per that order, you're paying 15,000.
What has happened? I have filed a memo. I'm not able to. I will place it, my lord. Even the trial court also. I filed that memo. My friend is withdrawn also.
On 24/1/2018.
My friend has also withdrawn that
an
memo.
order.
Yes.
Observing the fact that before the mediation, as per the settlement arrived at before the mediation, every month the petitioner is paying 15,000, and the wife is the one who has filed the petition, but not the children. But the maintenance is awarded to the children also. The court recording the fact that every month 15,000 is paid by the husband had stayed the order. This order is dated 24/1/2018. The petitioner shall place before this court right from 24/1/2018 till now what are the amounts that are deposited by the petitioner, what are amounts paid to the petitioner, to the respondent wife. List this matter day after tomorrow.
Respondent's wife, as well as after the modification of the order, my lord.
No, please understand why the court had stayed this order. Application is filed by the wife. Children are not the petitioners. Why the court had granted that amount is the ground. Yes, day after tomorrow.
My lord.
Day after tomorrow.
My lord, only because my party is not there. There's in Kerala. He is gone for some 1 week's time, my lord. Because
Monday, by Monday, if the court finds that The 15,000 is not being, please listen. 15,000
we'll
is
file
not
a
being,
memo of calculation.
15,000 is not being paid to the wife. The stay granted by this court will be vacated on Monday and no further time will be granted. Even if there is no representation on behalf of the petitioner on that day, on that count also, the stay granted by this court will be vacated.
It's not 15,000, my lord. The modification is only 5,000 to be deposited as per the order of this honorable court. It is not 15,000, my lord.
Yes,
As per the terms of this order, my lord.
The court has recorded the fact that you are
Yes, ma'am.
paying 15,000.
Paying 15,000 earlier, but after modification, my lord, the children are not entitled. And the wife, what has happened, it is reduced. There is an order passed by this honorable court.
You file the memo. We'll see.
Yes, I'll file
That
this.
day I can see that all, that order also.
Yes, madam.
Yes, Monday. 25.
My lord, I appear for the petitioner husband, my lord. This honorable court, after hearing, in the last date of hearing, my lord, after hearing the matter, my lord, adjourned the matter to today because there are two cases that are pending, my lord. One is restitution, which is filed in Tirupati, that was posted for judgment on 17/6. But now it is adjourned to 36, my lord. And there's a criminal appeal that is filed against the order of the DV Act, wherein the lower court has ordered for 15,000 plus the educational expenses. 15,000 I have been paying. The educational expenses is being stayed. Even in that case also there is a judgment that is still pending. It is on 18/7, my lord. So both the cases are pending. However, my lord, so far I have paid 19,40,000, my lord, from the date of from 2015 till today, and I am paying 15,000 every month, my lord, as ordered by the
Yes,
DV.
what do you say? No, 12 lakhs, like how you have calculated it, at what amount? Yes, this is smarter, up to 2 weeks. This way.
This case, my lord, I am appearing for petitioner. Last date of hearing, your lordship directed them to provide documents of title for, my lord, registration of portion of the site. And they have provided, I have drafted sale deed and I have forwarded to them. However, my lord, another 2 weeks may be granted because they have provided e-kata without bifurcating that portion of the property. That will not be registered by virtue of a notification issued by the government. Without bifurcation and getting e-kata.
Are they gift deed? He'll ready for that because they have made it a sale deed. It's not a sale transaction. That's what we are suggesting, that because only Friday they informed us that they are making a draft of the sale deed. So that my senior suggested that to relinquish deed or gift deed, we are ready for that. But they are not asked for any other further document till today. Now they are saying that this is not. And second thing,
They
for
are
the
also
mutual
aware.
diverse consent, they are not saying anything.
I need not say this is government notification for bifurcation of kata. That is, they are also aware of that. We have intimated to our senior to get. We will draft and send gift deed also.
This court has passed an order on so and so and directed the parties to comply with the order. It is submitted that and also the petitioner that the respondent has complied with the order, and for the other formalities, it may take another 2 weeks. This is matter after 2 weeks.
One request,
My lord.
and also
My lord.
mutual diverse, because previously they are agreed and
That
took
we
5
will-
lakhs
we will-
rupees.
we
Now
will
they are
file
not
because-
turned. Now after 3 years here, again they are coming with the new things. So that's first mutual consent diverse also simultaneously applied.
Kindly see the order sheet that 20,000 rupees to be deposited, but they have not deposited till now during the pendency. But your
Yes, my
lordship
lord.
directed.
That is for the mutual consent diverse completed of that. But
No,
they are
how
not.
that she
They are
can
not
lead
filed a
life.
mutual diverse consent.
He
They are
has
not
got married during the pendency of the marriage of first wife. He has married, and this honorable court twice
But one
directed to
request
pay
before this court.
maintenance.
Please understand, it is a compromise. The court will not compel
Yes.
you. If you are not interested, court is not interested for this. So instead of arguing, try to settle it.
My lord, we are ready for everything. They are not opening. Today only they come and here and saying that.
Even if you are ready, he is not ready, also court can't help you.
Yes, I am ready. I have sent a sale.
You are ready, and who's not? Both of you ready, is the court stopping?
Correct.
Court is not stopping.
Yes,
Do
yes,
it. What is supposed to
definitely,
be
I
done?
agree with your lordship.
List after 2 weeks.
Please.
Much obliged.
Much.
Appearing for respondent, my lord. Your lordship had directed this matter to be listed in July, and we are yet to receive some
The
documents.
matter was listed in special court matters, my lordship.
No representation on respondent side.
Lordship,
My
I'm-
lordship, from last
yeah.
3 occasions, there was no,
Because this matter was listed for 7th July. On 5th June, your lordship had given the
Must have
date.
moved a memo why the matter has come up.
it has come in special court matters, my lordship.
Oh, specially mentioned cases. RPFC.
Yes, my lordship.
List is smarter. After 2 weeks. Or on the same day. Some July something is, yes.
Grateful, your lordship.
Yes, 28.
27. 27.
28.
I'm sorry, 27.
Appearing for petitioner, my lordship.
That's in this matter. First matter is, my lord, subsequently filed, and the second matter, RPFC 228 is for first earlier.
The state matters.
Yes, my lord.
This also after 2 weeks. Yes, next.
My lord, one submission. 228, I have sought for a stay of further proceeding. I have sought for a stay of order passed by
The
the Honorable
order is
Family-
at page number
Family Court.
26, my lordship.
28, give 28.
Please, 228, my lord. My lord, in this matter, my lord, the,
RPFC 135.
my lord, 228, my lord. 228, my lord.
This is an old matter of 2024. What is the stay now?
My lord, what happened, my lord?
My lord, the
Early-
Kelpa has passed an interim or maintenance
earlier,
for
my
rupees
lord.
4,000, my lordship, which they are has.
My lord, may kindly see what happened. Earlier, I have challenged the order passed by, my lord, may kindly see page number 40, my lord, 41, my lord.
For whom you are appearing?
My lord, I am appearing for husband, my lord.
You are appearing for the wife.
Wife.
Yes, my lord.
Now, what is this next matter where there is a IA for stay?
That is for enhancement of the interim.
My lord, II for stay is, my lord, in that,
Stay in that.
I want stay in that matter, my lord. I'm sorry.
They are seeking for the stay, my lordship. We are seeking for the enhancement of the.
No.
maintenance.
RPFC 130,
Not 134, my lord, 228.
28 and 25.
Yes, my lord.
25 is who's the RPFC?
25 is his wife, their petitioner.
You're seeking enhancement in that.
Enhancement of the.
The 27. Then what about 27.1? When is the impugned order passed?
My lord, may kindly see impugned order passed is annexure.
8.
My lord, dated
17/8/2024.
17 August 2024, my lord.
No, 17 August 2024 order. We will
Yes.
stay in 2025
My
June.
lord, earlier, my lord, I have made submission, my lord. After appearance of the other side, we'll consider my lord, the Assembly Court has adjourned. My lord, may kindly see this Assembly.
If the court is not granting stay at that point of time,
Please, my lord.
it means court is not convinced with with the case. That's why it will general. Otherwise, in all these matters, there will be a stay granted.
My lord,
We will hear both the matters.
only one submission, my lord.
We will hear.
My lord, this
Matter may
Assembly Court.
be heard, my lordship.
My lord, may kindly see only for a moment. Page number 42, my lord. My lord, earlier order dated 29/10/2018, RPFC, this Assembly Court, my lord, has earlier in this matter, RPFC 18/2019, my lord has heard the matter, and my lord has directed them to directed the husband to file application insofar as, and my lord has directed the other side has submitted that she is working as a tailor, my lord. My lord, at that point of time, in RPFC number 18/19, this Assembly Court has clearly directed both the parties shall appear before the trial court and file assets and liabilities. My lord, after remand of the matter, my lord, may kindly see page number 42, RPFC 18/19. My lord, this Assembly Court has clearly directed both the parties to appear before the trial court and file affidavit and liabilities, my lord. The wife, she has not filed the affidavit and liabilities. My lord, in fact, I have filed affidavit and liability. I have stated, my lord, my employer has terminated me from the service. My lord, I have also stated in my affidavit and liability, my employer is terminated. Earlier I have placed the record of my salary slip before the trial court. I am getting 20,000 salary, my lord. Subsequently, my lord, my employer has terminated. And the other side, though she is working, my lord, she has not filed as per this Assembly Court.
Not working, my lord.
She has.
Have you filed your SSN liability?
No, my lord.
Why?
She was not been directed by
Huh?
tail court. She was not been directed from the tail court council, my lord.
What is that? There was an order earlier for
Yes,
both
ma'am.
of you to file. Why the court will give you a invitation that you please come file
No, no, madam.
You
There
that-
was some miscommunication between.
this first matter, RPFC 25, no, 2028.
Page number 46, madam.
Then counsel to the petitioner submits that. Where is the order of this court?
Madam, page number 46, madam. Petition allowed in part and impugned order dated 20.
Here,
Please,
in
madam.
the earlier round of litigation, RPFC number 18 of 2019 was disposed of by order dated 5th June 2024, directing by setting aside the impugned order, and the matter is remanded to the family court for fresh consideration. Both the parties were directed to appear on 1st July 2024 without waiting for the notice, and they shall file the respective affidavits of assets and liabilities on the same day. And the trial court is directed, and the family court is directed to dispose of the matter with an outer limit of 2 months. Then counsel appearing for the husband submits that the court, after the remand, the petitioner had filed the husband has filed his statement of assets and liabilities. The wife had failed to file her as a statement of assets and liabilities. In spite of the same, the court had granted maintenance of
4,000, madam.
maintenance of 4,000. It is a specific case that he lost his job. Even the same is placed on record. The same was not considered by the court, considering the fact that in spite of an order passed by the court with regard to filing of the statement of assets and liabilities, the wife had failed to file the same. That too, when it is the specific case of the husband that she is earning and she is working, and even as per the mandate by the Honorable Apex Court in Rajneesh versus Neha, it's a duty of the wife to file her statement of assets and liabilities. Considering the same, there shall be stay of all further proceedings or pursuant to the order dated so and so, so and so.
Please. Great.
Next.
Please, my lord, for the petitioner. So
Yes.
husband's petition against my lord maintenance of 9,000 towards wife and 5,000 towards the child.
14,000 is granted.
14,000 in all.
What is your income?
My income is 27,000. I'm a KSRTC driver. What has happened is, my lord, the learned trial judge has taken my gross income. There is a deduction of 10,000 rupees.
For what?
From salary.
For what?
Please, my lord.
For what purpose is the deduction?
Not PF and other things, regular deductions.
27,000, 10,000 will be deducted toward PF.
37,000. I'll just please turn to page 19.
Page number?
90. So his gross income is 37,946. Total deductions of 10,603. This is the salary slip of KSRTC. The remaining is 27,340. I have a handicapped brother and an aged mother to take care of. Lord, some, if I give off half
No,
of
you have a daughter, you have a wife also.
Agreed. Our allegation is that the wife has an illicit relationship that's taken care of by a separate matrimonial case. But the allegation is that she has an illicit assault. That's why we are not living together.
Pay 10,000. The land council.
9,000.
Then counsel for the petitioner submits that the salary of the take-home salary is 27,000, and he has a aged mother and a handicapped brother to take care of. And the court had failed to consider all these aspects. Considering the same, there shall be a stay of all further proceedings on the condition that the petitioner shall continue to pay 5,000 to the wife and 5,000 to the child, and by 5th of every succeeding month, and the arrears also at so and so within 8 weeks from today, same default order.
This case, here for the
In the first case, I am appearing for the respondent. Second, connected case for the petitioner husband.
Lordship, we are for the petitioner. It's for the wife in the first matter. Lordship, order has been passed 3 years back. Till day, not even a single fees has been paid. Since there is a female child.
Stay is there in this?
No, my Lordship. No stay.
Stay in his petition?
I have filed a petition and
We are
seeking
for
the
the
stay.
announcement.
Yes.
What I'm saying, in his petition, is there any stay?
Yes, no stay.
No
Then why you not be, why didn't you file the execution?
With your lordship permission, I filed an application under 91 of CRPC for production of the documents, where she is having the income of 22 lakhs, saying that I don't have any sort of income. I don't have anything for the
What happened to that?
food or anything.
What happened to that?
Yes, she has not filed it and she has suppressed it. Whatsoever the judgment or the order obtained by any of the courts by way of suppression and misrepresentation, that order need not be enforceable, because she is the software engineer and she is working and she is getting the income of 22 lakhs, where
I am asking you.
I'm the husband, I don't have any job. And whatsoever the torture given by the wife, because of due to that, I lost the job also. I am seeking the help of others by begging and feeding the age-old parents. They are bedridden. If that is the situation, this is the bank, that is one where she is having.
What is that?
This is the bank statement where she is
You
having.
please come there, please. Mr. Counsel, please listen to the court,
Yes,
and if you
my
can
lord.
answer the
Yes,
court's
my
query,
lord.
then we will be able to, I can understand, you have to understand.
22 lakhs, Bank of Baroda.
I'm just asking you a query, please understand.
Yes, my lord.
You said that an application is filed under 91. What happened to that?
Still pending and they have not filed objection.
When was it filed?
In the initial stage itself, after the judgment.
my
Yes,
lordship.
it is pending. I
When
have
is it?
I have filed along with the petition itself. May I kindly peruse the annexure, that is last page. Page number 58, 56 to 58. May I kindly peruse in the petition.
What do you say?
My Lordship, I'm staying in the Davangere, where I'm still in the mercy of my parents and my kid.
Did you file your objections or were your
Definitely,
counter?
my Lordship, we have filed the objections. We are not earning any single rupee. We are living in the mercy of the petitioner. No document record has been submitted stating that I have a 22 lakhs of kind of earnings. I have not even have a single rupee earning from any kind of source, my Lordship. This is my clear submission.
You have all the
This
documents.
is the misrepresentation whatsoever came before the.
Let them produce a
court and
document, my
obtaining
Lordship.
the order.
Oral
By
submission
way of
and document submission is
misrepresentation
totally
and
different, my
suppression of
Lordship.
fact. That's what in Chengal Rai and I do versus
What I'll do
Janardhan.
is, I'll do one
Clearly.
thing. I will impose costs on both the councils for not letting the court to do its work. Because you have to listen to the court,
Yes,
Mr.
my lord.
Counsel.
Yes, my lord.
What is this?
I may be permitted
Not
to submit.
permitted. When he is submitting, you have to
Yes,
keep, you have to wait
yes,
for
my
your
lord.
turn.
Yes, my lord.
You are in High Court, please remember that.
Yes, my lord.
Give those, the second set of papers.
Page number 56. Is the W of restitution, converted petition. Page number 56, 258. The application, copy of the application under section 91 of CRPC. They have not filed objection till today.
Give the first set of papers. Where is your statement of assets and liabilities? Page number. Yes, Mr. Counsel.
My
What are
lordship,
your statements of assets and liabilities?
my lordship, we have filed the statement of objection. Just a moment, my lordship. I'm checking those documents.
If Your Honor's permission, I may be permitted to sit. I have got a little
Please be
problem.
seated. Please be
That's why I
seated.
could not able to come to the
Please be
event.
seated. What is this, Mr. Counsel?
Sorry, my
When you're
lordship.
seeking enhancement, all those documents should be here before the court.
My lordship, we have submitted regarding the bills and all those documents.
Not about the bills. There is a format for filing statement of assets and liabilities.
My lordship, seeking a short time, my lordship. We have filed the objections. We'll produce these documents before the court. And we have also filed regarding this
It
objection.
is both these matters next week.
2 weeks, 2 months. 2
4
Kindly,
weeks.
ma'am. Kindly,
It's
lordship.
after 4 weeks.
That this was heard for some time on last occasion on application to section 340. My lord, I represent the wife, my lord, against whom, my lord, an order, my lord, is passed. My lord, to initiate, my lord, proceedings under section 340 for my lord, allegedly submitting, my lord, a false affidavit. In fact, my lord, the whole proceedings, my lord, are to terminated. My lord, the 3 MFAs, my lord, that are filed are listed today, my lord, and I seek some accommodation so that, my lord, I could.
My lord, on the last date of hearing, matter was heard, my lord. Matter was heard, my lord, on the last date of hearing. My lord,
You know what has
on
happened
the,
to
on
the
the ground,
MFA?
my lord.
What is it the MFA listed today?
My lord, yes, my lord, but that is a complete different, my lord, different proceedings. My lord, wherein, my lord, the another affidavit.
Even on the last occasion also, on this ground, it is accommodated.
Yes,
not
my
on this.
In fact, my lords were of the view, my lords would tag it along with the MFA, but my lord, they had their own grievances, my lord, that's all.
That is completely different.
Because that the connected MFA is coming up for hearing.
My lord.
This is matter on Monday.
Right.
Next.
May I please move?
Yes, what was the proposal? What was the proposal?
It's the proposal, my lords, like my lord suggested to figure out if there's a possibility of sending the child to a boarding school, my lords, that we inquired. My lords, like most of the schools, my lords, they don't have the admissions are not open in the mid of the year. So that is one thing. And the client has also discussed with the child. It is my instruction, my lords, that the child literally cried on that day. He said like he did not understand the repercussions of making such statements before this court. And he wants that status quo to be reordered, that he wants to stay back with his father, continue with the same school. And my lords, that apart, my lords, the child was supposed to be sent to the school once he was taken into the custody of the father. The mother did not even return back the school bag, the uniform. She is withholding it despite several requests. They're not coming forward to give those also. So I could not send the child until Friday. Today I've sent him, but without the books and all. There's a direction to that effect. That is one thing.
Even for this, why the court should give a direction? To give
They're
the
not
books
giving,
back?
lords. They don't even understand the problem, lords. They're even letting the child not to go to school. Even despite request to send the school bag and the uniform withheld by the mother, she is not giving it.
What are your instructions?
My lord, all that is again, my lord, the same thing.
What same thing, sir?
Boarding school, my lord, which school they went, which school they have ascertained. Vaguely, if they wanted to say whatever it wanted to say, my lord, it is of no use at all. In fact, they should be very responsible in making submissions. Which school they have visited and where they have found out, all that it is their own decision. Whatever they wanted from the honorable court. That is the thing. That is all. If that is the case, it's very difficult, my lord. The Honorable Court has also heard the child. So
May-
taking into consideration, my lord, the Honorable Court has suggested the parties to work out the remedies. Since
May-
the child cannot continue with the further, it has, Honorable Court has said, now it is a parties who should work it out, not give big reasons or excuses that we did
May I
not find
submit?
any school in the midst of all that is, well, now, just now, even admissions are on. This is the June month. In India, it is only June month it starts. What is the best in the interest of the child? It should be seen by both the parents. This is my respectful submission. It is not from very beginning of the proceedings cases, my lord. If entire file is read out, there was no reason at all. In fact, we brought the child unilaterally, kept the child here. All that happened. Now 6 years has lapsed now. Now child comes and says before the Honorable Court that child doesn't want to continue with the father. And it cannot, even Honorable Court said, it cannot be now sent to along with the mother. Now, what is the best thing that has to be worked out is to be seen in the light of all this happenings before the Honorable Courts. Now, courts have said, yes, we have to work it out. Not the, again, ask the child, friends, which child would say that it cannot leave the school, it cannot leave the friends? All that is again, my lord.
I'm not
it is
making
all,
that is not.
It is all, my lord. It's just imagination of my learned friend and the father. That cannot happen at all, my lord.
Why your learned friend should imagine? It's for the father.
It's just, no, my lord, it's an imagination, that is all. But
Sir, ನೀವೇ ಹೇಳ್ತೀರಾ,
we
ನಾನು
have to
ಬಿಟ್ಲಕ್
work
ಬಿಡ್ತೀರಾ?
it out. Here, even mother wants a child now. Desperately, she is there because when she got the mails, my lord, the child, mother has come and
Then-
the orders, my lord,
Then,
repeatedly.
what are the efforts for the mother and what
Please.
school she found?
My lord, here, my lord, the entire order, my learned friend, I would, if I
No, no,
permitted,
let's
my
not-
lord,
let's not
it
go
is
into
very
that.
repeatedly.
No, we'll not go into that. I'm asking, what are the efforts from the mother and what are the schools according to you that are open?
Madam,
for,
Tumkur, my lord, we have found one school there. Tumkur, there is a school, boarding school. We have spoke to them. They are ready.
What is the name of the school?
All that I will furnish, my lord. We don't have any problem in that, my lord. Tomorrow, my lord, one of my her relative along with had gone there. They have spoke there, and their school has also accepted. All that details will be furnished because what is the Honorable Court has said. First, I also wanted to hear from their side as to which school they have went and.
You can also give those particulars to them so that they will also verify.
They did not even try to contact me, my lords. In fact, when I tried to contact her, figuring out whether she can hand over the school bags and the other stuff to send the child to school, she neither takes my call and further she refuses to hand over the uniforms.
Madam.
And that's the conduct of the party, my lords. And my lords, I've inquired with 3 schools. I'm sorry. I've inquired with 3 schools. One is Hebnizer, Trio, and Jain Heritage, my lords. All of these 3 school, my lords, they have a fee structure of around 15 to 20 lakhs, varying in between. But again, they have not confirmed on the admission part. That apart, my lords, even the child has expressed his concern about going to the boarding school because all throughout he has been with the parents, he has been with the father, an extended family to support him. And now, my lords, at this stage, my lords, that too when the child is in his 9th standard and the board exams are coming on the next year, my lords, changing over the school, and that all possibilities has to be again looked into, my lords, as to how we can work out on things, my lords. That is also an, because all these days, my lords, the father had a hands-on over the boy. He used to teach him on his academic and he used to take him to the football, my lords. He attends a club. He plays for a club for the past 4 or 5 years. So he expressed concern that he doesn't want to lose out on that. He's been playing football for the last 6 years, my lords, and he's representing one club, plays in district level, my lords. So all these concerns are there that we have to, my lords, again have to talk to the child. But he literally cried when I told him that the judge has suggested to send you to a boarding school. May.
If they were to just put the terms with which I have to take care of the child and they want to exercise their visitation rights, I'll prevail upon this because ultimately it's a question of what extent I am required to.
The interaction with the child was showing 100% reluctance to stay with the father that day. That was the thing. And what the court thought was, because he was continuously with the father, For all the small things, he has an advantage of talking to the mother or complaining to the mother, he's doing it. And I'm told he's also not doing good in the academics. And with all this is happening, then if he's in his, not as a punishment, even if parents are together, children are doing.
They are, my lords. Absolutely no problem.
So if he is in a boarding school, now he has an environment where he can speak to the mother, he can speak to the father. He cannot have any kind of complaints against either of them. And sending the child to US is out of question, as he is not having any, the passport, the visa and all, and he has some difficulties to go to US. So then I felt, whatever the weekend that's available for the visitation and all, her mother or maternal uncle, boy's maternal uncle is there. I think it's good with him. So out of, for example, it should be like 60 to the father and 40 to them. So they will be visiting, and all the holidays, 50% to the mother, 50% to the.
No problem. Absolutely no problem.
I think that will be the manner in which further problems
Lord's
can
only
be.
concern is because we have a support system, everything is in place. If the child per se, my lords, is not, because I don't want the child's child to be affected at
In
this
the house,
stage.
except he and his father, nobody else will come. They will only be there. Nothing, no extended family, according to him, what he informed to the
My lords,
court.
what happens, the children of present age, notice they feel that every interference by the elders is an interference into their privacy. It's the privacy of the child is completely respected, because we have gone into a different realm altogether.
One more thing, why all the more it is good for him, I am suggesting him. He tells the court, please send me somewhere where my father can't reach me. That is
Parental,
something
my lords, what happens?
No, that is a very big statement, which is not good for him.
Lords, I fully understand, but the converse of it, what I want to submit is that a child to express a statement of that kind, my lords, is too premature to say so, because he has not understood the concept of parenting.
Correct.
So now, my lords, we have to make him understand if that is something which has happened.
this
Now,
will not
onus
happen.
is now.
It will not
My lords,
happen.
I don't want to fail in my duties. My lords, if there is something which my son feels bad about me, I will not be a failed father. Not say I'll put in all efforts to see to it that I'll be a good father. Not to say that although the son says so, therefore I should be with it. Not then my parenting notes will be. It is at stake. Not I want to be a good father.
No, it is not that the court is considering whatever the boy says is correct.
Yes.
And that is not the impression of the court.
And
Court understands in this kind of, in this scenario, boy has the advantage of taking his own decisions. So ultimately, now he is already 14.
Another
Once
4 years.
he'll become major. And this 4 years of parenting by the father, all the more reason that he will turn, because it's all this age of teenage and all.
Lords, what
he'll have
happens?
that.
Your lordships would be aware, Lords. When I am spending more time with the child, then I am required to discipline him in certain things.
That's what.
So my interaction is completely different.
That's precisely I'm saying.
Then when the mother comes for a very limited sphere, she has no
Pamper
time for
him
it
and,
because she has to express her love and affection.
Correct.
She is overwhelming and there is nothing which she can do insofar. So the child will feel, if she wants to put us in a scale, the child will always start feeling that, look, here is a father who has been so strict. He has not been doing that. But look at the mother, how this is there. This is very natural for a child to say so.
That's why I want him to be out of it and show the child that, he will also have there's advantages. Boy will have good education without any kind of, for everything. If father says something, how to, inform this to mother and how to seek her sympathy.
That's the reason, my lords. I don't want to, now I don't want to be a failed father. Lords, I have been a good father. I know, my lords, the child may have a grievance, but I've interacted with them. I have been a good father. What it requires to exercise parental authority, and to the extent I've exercised it, because I have a responsibility towards the child. I cannot let him laissez-faire, free for, that cannot be done. There are certain places where I might have said, no, you cannot touch the mobile. You will have to sit and read. Every parent does it today. The children will always have a grievance against that the father is not permitting me to play games. He's not permitting me my digital time.
Fortunately, he doesn't have all the privileges that a normal father will have.
That's true, my lords. That's the reason why I said, my
The
lords.
whole problem.
Lords, we will have a support system. The other father will have a support system of none other than the mother. Here we don't have it. Lords, the husband and wife may be at loggerheads. But I have never ever prevented the child to interact with the mother. I have never behaved in a manner that it would prevent the mother to exercise her parental authority or to have her love and affection for the child. Even insofar as her relatives is concerned, I have never come in the way. Lords, I want a holistic growth of the child. I know that my child wants to become a social being. I want the child to be in the midst of everyone. I don't want the child to be isolated from us. The child, my child is a social being. He should be amongst us. He want to be with them. Yes, I have no problems. In the vacations, let him spend time. In the weekends, let him spend time. I want him to be a social being.
Come up with that kind of, no, about.
I will come out with
No,
a proposal.
all the protocols, right from his, no, because he is in the exclusive custody of the father. Mother should know what's all happening to him.
Certainly.
Right from his medical, physical,
Everything, my lords,
psychological.
everything.
There is a protocol which
Yes.
they follow in yours. If she wants those parameters to be followed by
No
the father,
difficulty.
which is definitely in the interest of the child, there cannot be any difficulty to the father.
I'm making a statement in furtherance of what your lordship is saying. I am also required to bring up the child to the satisfaction of my mother because it is the mother's child as well. I have that feeling. I'm not bringing up the child in a manner that it should start disliking the mother. 4 years has not made any difference for the child. I'm ensuring that he likes his mother because I want his mother to like him. I wanted this to be intact. I may have differences with her, but I don't want the child to have differences with any single member of the family. I'm exposing him to every single member. I want him to be a social being. Otherwise, I'll not be successful in fathering the child.
Then come up with that plan.
I'll definitely come up with a
Come up
proposal.
with a
my lords.
plan where everything, right from, like, everything should be on a paper.
Including that protocol, I will give the proposal.
Everything
my lords.
about what is, how, when, right from his whatever medical vaccination, whatever way, everything, like how he has been, his curricular, extracurricular, everything. And with regard to the school also, mother should be in the loop.
Yes.
Mother should be in the group where she would be knowing everything that's happening in the school. And and she has her own apprehensions with regard to the health concerns of the child. She says that there is something, the family has some issues with regard to the kidneys and all, and this boy also has a problem. How
No,
is
no,
it?
I know.
How it is? No,
Well,
that's
of course,
her
there's nothing
apprehension.
wrong for a mother to say that, mother should
so-
always be careful about the
And-
child. Nothing
and,
wrong. We
and
will
then-
address it.
And then her brother, who stays very close to the place where the father and the child are staying. What about his weekend visitation to
Something
them?
good. These are all.
And now we will clarify in this order
Yes.
about the mother's, as you say, whenever she comes, that clarity we give.
Very
Whenever she comes, she will inform the father. On such information, the father shall be giving the custody to the mother, and the mother during the school days would be, sending the child to the school, and after the school, he will be with the mother, but all other activities should go on.
Absolutely no difficulty, my lords. Whatever your lordship is
Yes.
saying is in the back of
Lord,
our mind. We'll do it.
6 years before, my lord, almost 4 years before, the court has considered all this, my lord. Now, my lord, after 4 years, there is a change, my lord. That is what, when your lordship had heard the parties in person and now,
Your client's request.
my
1 minute.
argument may be
No, your client's
convincing,
request,
but
1 minute.
what
Your
exactly
client's
is the
request-
parties stand,
Please
my lord?
understand.
Yes.
Your client's request as far as taking the child to yours is concerned, that cannot be granted.
My lord, I didn't.
No, please
He wanted
listen,
to work it
please
out.
listen.
Yes.
That will not work. Then I made it very clear to her. Then the second, after all the apprehensions she has with regard to his all, like the father, what he is not doing, what he is supposed to do, you can come up with your, the way how all these things have to be done. Everything 1, 2, 3, 4, everything let her say on a paper and give it to them.
Lords, we can easily exchange, my lords.
would
What they
only
want,
remain
let
on
them give
paper,
it.
my
What I
lord.
want, I will give it.
It will only remain on paper because the character and behavior of a person, it all depends upon.
If you say so,
My lord, here, my
if
lord,
the
what
court
happens, my
passes
lord,
an order, no,
even-
Mr. Counsel,
Yes,
if the court passes an order, if you say that it's a paper order, then we don't have to.
No, my lord, what I'm
That's
saying,
how
my
they are
lord,
treated, your lordship.
he will not, he has not even, my lord, my counsel has said, my lord, that everything is followed, all the directions given by this honorable court is followed. Because, my lord, none of these directions
What
have
is
been
the
followed
direction
till
which-
now, my lord.
What is the direction which is
This
not
is the
followed?
order, my lord.
What is that?
My lord, mother is entitled to communicate with the child through phone, video call, Skype, etc. All this, my lord. Again, the court has said the
What we will do is,
Yes, my lord.
periodically, whatever the conditions that are complied, periodically a complaints report shall be filed before the family court by the father. And
Yes.
all the relevant things shall be placed.
It's a very, very fair suggestion, my lords.
So
Very fair
that
suggestion.
now, the court, as you say, 1, 2, 3, 4, 5, 6, 10 kind of directions are given by the court. With regard to the compliance of that, if he has led the child to speak with the mother, there will be a call record, whatever it is. All that complaints will be filed before the family court periodically, or we say you, like 2 months, once in 2 months, like that. And whenever the mother comes to India, mother will not, like how she did at the last occasion. She'll not go to the school and take her. She'll not go to the school. She will inform it by way of any means known to law to the father, and he has to then give the custody to the mother, and the mother accordingly, she has to, all other activities which were going on should go on. And with regard to all her apprehensions, with regard to his medical and other psychological things, what she wants the father to do, and whether he is doing it or not, for that also a report will be filed. Let her come up with all the concerns.
My
My
lord.
lords, if I make one submission.
Yes.
There was a division bench order, my lords, laying down all the conditions.
What are the conditions?
My lords, in page 18.
That's what you said now about this
No, my lords,
WhatsApp
the
calls
conditions
and
are
all.
already laid down, my lords. Let them follow it, because there's
You don't
one.
want anything more.
My lords, this is more.
Let's see.
more than
No
enough.
allegation
Let's see
that we
that.
have not.
My lord,
Today they
here,
are making
page 18, my lord.
1 minute.
Page
Then
18.
if they are sufficient, why did you go to the Supreme Court?
My lords, I didn't go to the Supreme Court, my lords. I was in a very limited aspect. Went to
Where
the
is that page number?
47, my lords.
20?
47, running page 47, my lords. Internal page 18, my lords, running page 47. The mother is entitled to communicate with the child through phone.
I am
video call.
suggesting far more than what it is.
Yes, see page, point number 5, my lords. During the period of her stay when she comes to India from US as aforesaid, the child will be in the exclusive custody of the petitioner. Because this was never done, my lords. I have requested, nothing happens. And then my son messages me saying that there's some problem in the house, dad is not behaving properly. And that is the reason I reacted as a mother instinct. I went and picked the child.
Anyhow,
Please,
no, what has happened, what was happening, let's forget about it. So whatever mother wants, let her exchange it with the father.
Please.
And let them, whatever they want to say, let them say. Looking at both the proposals, I will pass an order, and also we'll have a thorough check on that, like how it is going to be monitored also.
Yes, ma'am.
Yes. So when do you want?
I even suggest to these, the father and the mother, as a husband and wife, they might not have succeeded, but I don't want them to fail as parents. So even now
Unfortunately, they don't understand that.
I'm requesting both of them that let good sense prevail. You exchange whatever you want. Ultimately, both of you are interested in holistic development of the child. It's your child. So please don't get into a mood of
No, I
vengeance
told,
against the other.
I told him also, a day will
Therefore,
come.
my fervent request, even to him, I made a request, Minots, that there is no way that we will take this litigation as it's an adversary litigation. You people are apart, does not mean that you should not bestow your love and affection and permit the other person to bestow the love and affection to the child. Both are entitled to have the care and custody of the child. There is one judgment, my lords, of the division bench which dealt with the specific issue of joint parenting. I was the one who had assisted the bench, my lords, who passed this judgment. So that is essentially the concept with which it should happen when the husband as the husband and the wife have parted ways. They should not part ways as parents. That should remain. That is the concept with which let them give any suggestion, my lords. We will ensure that this is done.
Actually,
I'm also interested. We are not adversarial in this.
I tried to convince them for 2 hours on the other day. That I even told them that they will come, that the child will ask them, like, what did you do with my
Yes.
childhood? You people both with your this thing, you have spoiled my entire childhood. I do not have
In
any
fact,
good memories to think
in the
about.
proposal, I would definitely suggest that they will have to go together with the child on an excursion, on an outing, on a vacation. They should. The child wants. The child will be looking at the photographs which will be shared.
subject to certain things, my lord. Now, as a mother, I was concerned when my child messaged me saying that I.
No, this is not going to
Right.
go anywhere.
Please.
Heard the counsel appearing for the mother and the senior counsel appearing on behalf of the father. The earlier proposal with regard to the boarding school and all, it is submitted that the boy is not interested, and in the middle of the year, it is not feasible to join the boy. No admissions are open, which is denied with the counsel appearing for the mother. The mother concern was to, as a boy is interested to come to yours and stay with her, she wants to take the boy to yours. This court in the interaction on the last occasion and also in the earlier order passed, sending the boy at this stage to yours, where the father will not be in a position to meet the child in view of his visa issues, is not the right decision in the interest of the parties. Then coming to the other concerns of the mother, that the concerns about his academics, curricular, extracurricular activities, his medical concerns, both physical and psychological, and all are the main concerns of the mother. In this regard, what she expects the father to do and what are her expectations, or what are the in what interval she wants to speak with the child, and what are the other things which she want to be in connect with the father or the school to know about the activities of the boy, and all the requirements shall be placed before this court, and in advance a copy of the same shall be given to the counsel appearing for the for the father. And basing on the inputs from both the sides, the court will pass an order wherein wherein there will be a periodical monitoring by the family court with regard to the orders passed by this court in the best interest of the child. Does this matter when?
Sir, these interim arrangements, my lord, shall not have any bearing on the outcome of the family court judgment. Because these observation, my lord, custody of the child is sought, and even I will be asking custody of the child. In that case, my lord, all these, my lord, should not have any bearing, because she is entitled to custody according to me. I will be fighting the case there. Therefore, my lord, all these issues.
All these things have arisen because you wanted the custody of the child.
Yes.
And
That
you
will
went to
be
the Supreme
before
Court,
the.
and you went to the Supreme Court. Supreme Court said, you please ask all this before a court where the writ
Yes,
petition
my
is
lord.
pending.
GNDC.
Writ petition is
Either in
pending.
JWC
My lord,
or in the
even prior.
GNWC or
Yes,
the
my
writ
lord.
petition that's pending.
That
So
is.
they have moved here for some reason, what so happened. So while passing a final order, everything will be made clear. Nothing will come in your way.
Yes. That may,
So when do you want? No, in the final order, any order still needs to be dictated. Yes.
In respect of a child custody matters, no order is a final order. So
Because it keeps on changing the
my
circumstances.
lord, the child's wishes now has
I
changed.
will not have any objection
All
for
that
that.
in force of as that is concerned, my
Anyhow,
lord.
when do you want?
Lordship
When do
has
you want?
spoke to the child for a more.
I have all that is extracted in the order, in the earlier order. What was that? What happened that day? Where is that order?
It is not uploaded.
And then
taken up by Monday, my lords, 30th. If they can
do that.
Give it by 25th or 26th, we will have the weekend to plan up properly and come out with a proper proposal.
Alva? In the meantime, she be directed to hand over the school bag, uniform, everything. She is withholding, not able to send the child to school.
Why?
Seriously.
This court had interacted with the parties on 18/6/2025. In the next order, what has transpired on the day of interaction, all these things will be recorded by the court Monday.
Yes.
List on Monday. And the mother is here. Let the boy be with the mother.
Lords, what the mother has
Yes,
done, not as a grievance, my lords, the bag and his uniform, everything is with the mother.
No, he'll be going to the mother. Mother will take. She has to send him to the school.
Yes,
all
yes.
other.
She will do all
as long
that
as she is here, he'll be with her.
Yes, public.
Next,
There's one undertaking, because she's applied for the passport now. It's a
Lord,
fact.
whatever the
No, no,
order that may be passed,
she's applied for the passport.
we will
We have
not
got
be,
the
all that
information
is not
she's
going to
applied for
happen
the
at all, my
passport.
lord. Matter is being
As per
listed.
the order earlier passed with the court,
Yes, ma'am.
the mother had handed over the custody to the father. Now the mother is staying in India. As per the earlier order passed with the Supreme Court as well as the Honorable Apex Court as well as the division bench, the boy can be with the mother can have the custody of the child when she is in India. Hence, the father is directed to hand over the custody of the child to the mother, and the mother shall take care of all the activities that the child in the usual course is doing and doing. Next, it is brought to the notice of the court that mother has applied for the renewal of the visa. Passport, renewal of the
No,
passport.
my lord, it is not applied.
Renewal of the passport.
The lordship
which
may
is
kindly,
denied.
her submission may be taken that she has not applied it.
Which is denied by the, which is,
Yes,
I'm
ma'am.
recording that, which is denied by the land council appearing for the mother, and the mother is also before this court. The GNWC petition that is filed by the father is pending before the courts in India. It is needless to say that without the permission of the court, the boy cannot be taken outside the country.
Obliged.
Of course, your lordship is having this matter on Monday. The same visitation rights which the mother was having, the father will have to have unlimited access to the child. And weekend, the father can have an access. Till such time we arrive at an arrangement, it should not happen.
Anyhow, in the weekend, this all.
One week,
Whatever the
one week
previous
should not matter.
arrangement
I'll prevail upon it.
continue now, there cannot be any additional change in the order, madam.
The father has all the, as per the earlier order, whatever is the rights of the, what are the rights of the father with regard to the video call or the audio calls he is entitled to.
Please.
List on Monday.
Please, Vinos. Earlier order speaks only about the mother's access. Your lordship may not say as the earlier order. Only say that father is having.
Earlier order in this is not this order.
The division bench's order. Division bench's order speaks about the mother's right to have an access because the father is not father.
So we'll say the father can have the.
My lords, this is subject to mother being only in India, my lords. Now she's there only for a temporary period. Now they want an alteration to this order also.
No.
What is that?
Whenever she wants to call and talk.
That is allowed, my lords.
That only. During the stay, when the boy is with the mother's custody, the father can the boy as well as the father can have access to the audio video calls every
At any
day.
time. Please.
Yes.
Lord, in this matter, I appear for the respondent, Lord's wife.
Yes.
There is one short accommodation I wish, my lords. There was an order passed by this honorable court that on 22nd, after the child comes back from Spain from a football training that he was provided for, there has been an issue with, my lord, he has not come back yet, my lords. He's coming on the 24th. Only accommodation I want is 24th, my lords. I'm producing the flight ticket also. There was some miscommunication. 20th, my lords. Can it be on 29th, my lords? Because weekdays, 29th, the same complaint. We will do the compliance of the same order on 29th. We filed memo also. Last week itself we filed. But for
this court on on 4/6/2025 has passed an order, extract the operative portion of the order. It is brought to the notice of the court. You filed a memo stating that the boy is coming back to India on 25th.
24th,
tomorrow. He's coming on 24th June. June,
and
they
we'll
also
comply it on
the ticket in support of the same. It is submitted that the father can exercise the registration on 29th, 2025 as per the terms and conditions of the order dated 4/6/2025. This is matter on 4th of July.
28, there is an order of trial court
as a visitation right also been given.
My lords, the trial has concluded, final arguments are happening. At this stage, they have come to exercise this right, my lords.
You
Having
deny that
slept
there
over
is
it,
an order, 1 minute. You deny that there is an order on 29? Then? In your, the 28th and 29th or 29th and 30th? No, we'll have 2 days. Huh? No, not the day. As per the court order, it is submitted, as per the court order, the visitation go on 28th and the 29th visitation
29th.
shall be as per the order passed for this court.
grateful.
First, my lords, kindly take up the matter next week, my lord.
Next week, it's next week. Yes.
My lord,
Serial number
section
35, your lordship.
This application, my lord, is under challenged, my lord. My lordship.
What is the impugned order?
My lord, my impugned order, my lordship would get it in page number, starts from page number 20,
What is
my
the
lord.
order?
The order, my lord, runs like this, my lord. The petitioner is entitled to have the visiting right on first and third Saturday of every month.
You are for the father?
I am for the wife, my lord, the mother of the child.
What is
In
the
this case, I am for
difficulty?
the father, your lordship.
May I kindly see the observation of the trial court, my lord, page number 24, at paragraph number 10.
To have visitation rights on first and third Saturday
That
of
is
every
the
month.
10th paragraph, my lord.
Under the supervision of mother at visitation room of family court, Bangalore.
My lord, paragraph number 10 may kindly be seen. The husband has further submit that he has developed major depression disorder and constantly taking medical treatment. It appears that in the present situation of the husband is not in a position to
Correct.
take.
That's why it is given before the court, before the.
My lord,
What will happen?
monthly twice it is given, my lord, but as per now, my lord is not in a position to speak to the child. The child.
Yes, Mr. Counsel.
Your lordship, in this case, I am for the respondent, your lordship. The
Yes.
petition was filed in the year 2024 when the father had got certain amount of depression. He was in a
Is
slight
his
amount
mental
of depression.
condition not okay to
Now he is
speak to the-
perfectly all right. Perfectly all right. He in fact went to the trial court even on this Saturday, that is on the 21st. We went and signed the register also over
We'll
there.
see. What we do is this Saturday and Sunday or whatever, when is it? It has this week. First, third Saturday. This is the third
Lordship,
Saturday.
all that I'm submitting is it is not a
What
custody.
is the- 1 minute, 1 minute.
My lord, I think last Saturday
Then
was
we'll
the
do one thing.
21st.
No, it is not happening. So this coming Saturday, let there be a visitation. We'll see what is happening. The order dated.
Let it be for an hour, my lord, because it has
No,
been given for.
Lordship, you kindly see. I'm after all the father. All I'm asking was, what I actually sought
No,
was
it has
for
not-
custody, for the
Mr.
custody
Counsel,
from Friday
it
to
has not-
Sunday.
It has not happened so far, even according to you.
Because they have not been coming, your lordship.
Correct. That's why now the court is asking to have the visitation on this Saturday.
Yes, your lordship.
And we will list this matter on Tuesday. We will see what has happened on that day.
Yes, your
The
lordship.
land counsel appearing for the father, mother submits that the father is not in a fit state of mind to have the visitation. The same is denied with the land counsel for the respondent. Hence, this court deems it appropriate to direct the father to have the visitation on Saturday, date is 29th.
Please,
On 29th June, between 3 p.m. to
28th June, your lordship.
28th June, between 3 p.m. to
4
5 p.m.
1 hour, my lord, initially, my lord. Subject to that, we will get it.
Yes, 3 p.m. to 4 p.m.
3
Under
p.m.
the
to 5,
super-
your lordship. I'm meeting him after 6
No, we
months.
can
What is
have
1
it.
hour?
You can have it every week also if it works out.
Even if the petitioner
Yes, sir.
gets an assurance that he is fit, my
yes.
lord, we will also.
Under the supervision of the mother at visitation room of family court, Bangalore. However, he is not as per the terms laid down in the order passed for the family court dated 29th April 2025. Basing on how the visitation goes on that day, further orders will be passed. Listed on 3rd of July.
Please, ma'am.
Well,
Yes.
I only request is let there not be any sort of instigation from their side to the child not to come and visit the father, lordship. Because after all, the lordship is very well aware.
There shall be absolute cooperation from the mother in complying with the order of the court. Yes.
Much obliged.
Ask them, no, you can't do it.